Hello, hello, hello. Wait a minute, now we got something. Now we got something. Hello, hello, hello. Wait a minute. Sorry, y'all. Let me find out. Hold on. Let me change. Hello? Hello, hello. I don't know why I can't hear it in here. Well, I can hear it in here. Hold on. Hello, 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 hello. Y'all can hear me? Oh, you don't have the mod. It's not a mod. You can hear me now. It's not a mod. It's just what we do is Club Blue, right? It's not a mod. We don't even block nobody because we like to cuss them out and run them out of here, right? Like when somebody comes over a bunch of times or whatever, we just throw them in Club Blue. So it's no, it's like a club, not a membership or anything like that, right? That's what we do just to distinguish the people that come over a lot, what have you. Honey, we don't even block nobody. We like to cuss them out and run them out of here. Okay. I can hear, I can see me lighting up, but I can't see me coming through on this other device, and I don't understand that. But if you can hear me, I can hear myself. That's what's pissing me off. But y'all can hear me. So, hold on. So, listen, I got a lot of court cases to put on the record, right? But before we get into that, let's talk about some stuff that is off the record. You know what? I can't stand the fact that I cannot hear me. Hold on. Un momento, por favor. Hold on, hold on, hold on. Bluetooth connected. Okay, testing, testing. Testing, testing. Testing, testing. It's crazy. I know y'all can hear me because I see me lighting up, right? See me, I see the pulse, right? But I cannot stand the fact that I cannot hear me do this thing, right? But anyway, we'll go with it. So check this out, right? Of course, we got to speak on our favorite subject. These YouTube streets. hmm And I was listening to, I was listening to Sylvia earlier, and prior to that, right? Y'all know what has been going on in these streets. And of course, when you speak on cases, and you say something that someone is, disagrees, you get attacked, right? Whether you right or wrong, you get attacked. You get attacked for your opinion. You get attacked for the facts. You just get attacked. Somehow the lies are congratulated. I don't know how that works in your world, but it doesn't work that way in mine. That's not the type of life that I live. I'm not saying I ain't never told a lie. That's stupid. But I don't like liars. And when you tell enough lies, you are considered to be a liar. And when you just lie somebody up, oh my gosh, it is, oh, it doesn't affect a person's bottom line, right? I mean the bottom line, y'all heard me say the bottom line of your life, meaning not just your finances, your, what I mean, it doesn't affect the way you live, the way you enjoy life, whatever. It just makes it weird when you come online. Other than that, when you log off, your life still stays the same. Unless somebody goes to fucking around with it by doing the things that you see people do to each other online or in this sector, right? If you don't travel beyond these sector doors, right? But most of us do. And it's so many characters out here. I just, I'm not going to name names or whatever, but if you know, you know. And I mean, it's not going to be a naming ceremony today, but like I said, it is coming, right? Because I thought about it. I said, should I or should I not? And darling, honey, when I get my lick back, you know how I get it, okay? So, but I just am a person that believes that how you treat people matters, right? Whether you mad or not. Like, I watch a lot of those shows. And these people fight and whatever and act a fool. You have some people that will spit on people, throw their bodily fluids on people. And then you have people that won't do that. Okay? I use that as an example to say that you have people that will just stoop low, go as low as they can motherfucking go. And you have people that won't do that. They'll just stop at the back and forth. They'll, fight or whatever. But throwing pee and bow and spitting on people, nah, you have some people that will attack people's families and children and stuff like that. You have people that won't go that low, right? And then you have people that will go that low and lie about going that low. So It's just I'm saying what I'm saying is getting your lick back is hey, it ain't gonna kill nobody. It what it should tell you leave people the hell alone. And I am the one that will present that evidence. Hit you with those exhibits. The fuck? Because people like to lie. And I always say it, and a lot of times I just don't say nothing. One, because it really don't matter. Really, I really don't give a fuck. And but two, sometimes the truth is more damaging than the lie. So I just let the lie ride and whatever, people say what have. But when you have something, when you have, decent life, nice friends, family, whatever, one thing you don't like, it will also, when you have credentials, credibility, and degrees and shit like that, one thing you don't like to deal with is someone attacking your character, your credentials, your this, your that, whatever. Now, I mean, I tell you what it is, where it is, but I'll give you a little bit, and then you can make your opinions based on whatever. Like I showed my degrees, I showed my tax shit, right? Um, I don't think we should have to even go that far with this bullshit. This is not like a job for some of us. We ain't been getting paid to do this shit, to do none of it. We come out here and conduct our commentary as we see fit. If we are knowledgeable about some things, we share that knowledge. If we decide to, you know, but you have people out here that just woke up jealous, just was born jealous, just was born under the sign of being. It's just ridiculous, right? Where you have, and here's the thing, right? You have some people like Portia. Y'all remember Portia? Now, I think her level of understanding has gotten better, but maybe not, right? Because when it came to the area of knowledge on things that matter, right? She was clueless. But when it came to gossip and getting on the radio and having fun and whatever, I thought she was flawless with doing that, right? When she was working with the Ricky Smiley show. She flourished in that arena. She does well on TV. It's not that hard, right? But when it comes to things that are knowledge based, I mean, y'all remember that Underground Railroad thing? Y'all remember that? She thought that there was actually a train on the Underground Railroad. She actually thought it was 265 days in a year. That is slow. You slow in those areas. I mean, not getting how many days in a year. I mean that's something you learn. I don't know when we was taught that. But the Underground Railroad thing is like, oh my gosh. Like, girl, wasn't no train on the damn Underground Railroad. What up, Be Pretty? Wasn't no damn train on there. Some people understanding is like that. I don't know what the diagnosis for that is, but there's one. And you be like, huh? So a lot of people don't understand what's going on, right? Some of us speak, just remove some of the what they call intellectual talking. I have no idea why they consider what we were talking about intellectual. That right there tells you something, because that's just my normal in an informal setting. Normal setting, I don't speak like this. I don't have to, right? Because I'm around my peers, right? I don't have to speak like this. Of course, it's not much better. I'm gonna be me regardless, right? But nevertheless, I didn't name it um, intellectual speak. Others have. So I say, if you don't understand what people are saying, you shouldn't speak on it. Because time you speak on it, you're gonna sound dumb. You're gonna sound aloof, like you have no idea where you are. You don't know what you're talking about. And ain't nobody got time for that. Trying to decipher what That's why you can't go back and forth with the dumb and the slow and the liars and all. You can't even keep up, because they will have your head hurting. You will be popping and a leave. I have done it, trying to understand what somebody's like. You stopping it and rewinding, like what? Trying to put together what they trying to say. And it's just some conversations you just don't need to speak on. I'm never going to a convention that hosts doctors and speak on it. I'm not doing that. I don't have that knowledge. I'm y'all know smoke, baby, when it comes to things in the professional arena. Mm-mm. I like to be in the office, child, where it's safe. Uh-uh. I don't like being in type of conversations where, baby, people talking about metaphysics and let me go. And y'all know I love science, but I know where my levels are. I mean, it's just crazy. And so when I posted that story time about that girl who clearly suffers some type of mental issues, clearly, but I was asking, haven't y'all seen people like that around here? Don't they sound just like that girl? Mm, I got videos. Like, this motherfucker's insane. Um, and insane people support other insane people. Just look at where I'm going to put a name on this. Just look at where Audra finds home. And I did a whole study, and Sylvia mentioned, I think Audra came in her chair earlier. And that study I did that's on the live and read the paperwork. Do you know how hard it had you how hard it is and how crazy you got to be deemed mentally incapable to stand trial? Do you understand that? That's the last thing we want you to be. We need you to stand trial, honey. We need you to pass that. So, and y'all can tell when you live when she done come up here and all of that. Uh. But look where she finds refuge. Look where she finds comfort, welcome. People that understand her, people that's in her. And this is no attack on people with mental illnesses and stuff like that. I told you, right? I don't have a problem with nobody that's crazy. I don't have a problem with nobody that is addicted to substances and stuff. What I have a problem with is when they go to bother people and harass people. That's what I have a problem with. You can get high as the sky. As long as you ain't fuck with nobody, baby, do you. But when you go to fucking with people and interceding in their life and all this extra shit and lying, all this stuff, I have a problem with that. Because I swear that mental illness comes and goes. Goes away just long enough for you to fuck with people. So, um, I mean, all kinds of crazy shit, right? I heard Sylvia earlier, kind of summarizing some of the crazy shit have been said about her out here, right? And again, I'm not, no, I don't take up for nobody, whatever. I just point out what I think is right. I point out what I think is wrong. That's it. And I heard her talk about some of the things that she had to defend. Like if she was a person that was involved in some type of sexual assault or whatever, 9 out of 10 times she would have to register as a person, especially if she's found guilty. If she's found guilty, she has to register as a sex offender. Like what? Like it's just crazy. Like people, I don't get it. I don't get it. I don't get it. Just these people. And what kills me, they lie, they sell this type of shit, and then they have a bandwagon of people that supports that shit, that go along with it. Like, are you serious? Are you goddamn serious? Like, Bozo had put out a text that I had with somebody, right? And it was saying that I was saying, I can do something like I did for Levi, or something like that, whatever. And I never spoke on it. But to the slow, they think that's some kind of nefarious whatever. Well, if it was some kind of nefarious thing that I was doing underhand, whatever, do you think I would put it in a text? And more important, do you think I would do it? Are you insane? And then how they describe it, they think, oh, like what? You don't know what you're talking about. But I just let you talk. because it's funny to me. Like, like get a life. Like what? And here's the thing, right? I love to see people spin their wheels and try to figure it out, try to do this, whatever. It's funny to me. Because I already know something wrong with your motherfucking ass. And on top of it, it ain't your business. It ain't got nothing to do with you. It ain't your business. But no, and my thing is, when a dummy or a slow person tries to figure out what someone that's not dumb and that's not slow is talking about or doing, they're just going to run their pressure up and have a headache because they're too slow and whatever. They don't get it. They're just trying to make something out of that. And you can't do that because I don't even operate on trust and believe. I'm not going to do nothing for no goddamn strangers that I'm not allowed to do. I'm not going to do nothing for people I know that I'm not allowed to do. They just crazy, child. Just crazy, honey. Always on the attack, child. What they need to attack is just, I ain't gonna say that. Attack a school book. How about that? Attack. Do that. Make sure your diploma has a school name on it and not certificate of completion. And again, right? We have a thing over here called life shaming. That's not what I like to do. However, you have those who have tried to life shame me and life shame others. So they can get life shame. I bully the bully. I gaslight the motherfucking gaslighter. I don't like people fucking with people. And I definitely don't like nobody fucking with me. So one other thing I wanted to say, right? I do occasionally listen to people in those other sectors, right? Like the people that's had a falling out with Sylvia, whatever. I enjoy, some of their commentary, right? Because they talk about cases as well. They talk about um, celebrity news and things like that. And y'all know I like that. So I don't have an issue with them. I just wish everybody, would somehow just follow the truth and not the lies, and then and put how you feel about each other aside. That's just what I wish, right? But so let me say something when it comes to that, right? So I have I remember when Nyla, when the bozo had went over there and tried to give his side of this bullshit that he got going on right with Sylvia. Somebody took to her panel and pretty much, I think it was Domcat, and pretty much laid out how the bozo operates and whatever. And as per usual. I don't know how he finds out when people talk about his ass. Comes in the chat, he's like, says the same thing. Like these motherfuckers are, it's like Memorex. They repeat the same thing. These motherfuckers, I'm trying to tell you, something is wrong upstairs. Your response to the same situation is always the same answer. But if it's somebody you mad at, you change the person or whatever. That's some crazy shit. I don't give a fuck what nobody say. I don't give a damn if they come acting like I love the Lord and all this and whatever. Those are masks. These people put masks over what's really going on. Whether it's craziness, substance abuse, or whatever, they put a mask over it to keep you guys tuned in, to keep you on their side, to keep you liking it. I ain't gotta wear no goddamn mask. I ain't got shit to hide, shit I want to cover. I don't want to manipulate no goddamn body. But this the craziest shit. He'll come in there and say, now that you allow somebody on your panel to tell lies on me, I'm going to go live and tell the truth. How many times you done seen this motherfucker go into people chat and say the same motherfucking thing? And y'all, listen, there's certain things that I just cannot turn off. Y'all know that is a part of my skill set, tracking behavior, looking at behaviors and stuff. When I see it, I just can't ignore it. I can't do that. I don't turn it off. If I'm listening intently when these cases are going on, whatever, sometimes like when we was doing YSL, sometimes I'll stop and explain to you what they're talking about if I wasn't asleep. Then I had to go, somebody said, it went down in the courtroom. I'm like, oh Lord, then we have to go back and put it, I have to go through it again. But if I'm up and I catch it, I'm like, oh, let me stop and explain to you what they're talking about. Yeah, just like when the YSL had the whole thing with effect on the listener and extrinsic evidence and things of that nature, whatever. And I'm like, oh Lord, let me stop here, like, because it was a lot going on, right? We were able to get a bunch of lessons out of the YSL trial, and I thought we'd get a lot of lessons out of Lori Daybell, but it's kind of slow, so I don't know. But I just can't turn that off. So it's weird. But moving on to this ridiculous ass case that the bozo think is his case. He think it's his case. He doesn't understand that it's the state's case, and the state is going to prep their case. So again, just because someone is arrested for a crime, and we've seen this over and over again, doesn't mean that they're guilty. It just means that they had enough of probable cause to make an arrest. Probable cause, clear and convincing, those are the lowest standards. Now, they have to prep their case for a standard called beyond reasonable doubt. It's totally different. So, there's a couple things that I wanted to go over pursuant to what is going on, right? With that. And it is a case, is an actual case in this sector. Of course, we're going to speak on it. We're going to talk about it. There's no gag order. And if there was, the gag order wouldn't extend to us. If you're a defendant, your attorney may advise you not to speak on your case. But the judge is the only one that issues out gag orders. Okay. So has been a big question with regards to witnesses, right? Are there going to be witnesses? Were they witness this and that, whatever? This is what I suspect, which is funny as hell to me. I suspect that the bozo has named people as witnesses. They don't even know that they are witnesses. That's why he said, "Oh, I didn't know that was going to be released. I didn't know that." He said something like that. Huh? The prep of those witnesses would not be by the bozo. I think that's what he thinks. It would be by the state. The state will also determine if those witnesses will be in compliance of the federal rules of evidence, also the state rules, right? Um, as well as FRCRP, but we all call it FRCP, as well as OCGA. Okay, witnesses has to be admissible based on FRE, FRCRP, and OCGA. Have to be admissible, right? We're really based on FRE, right? So, pretty much, just with what we know about the case, right? You're going to deal with, and this is with any case, you're going to deal with Rule 401, 402, 403, and 404, right? Majority. And because there are witnesses, Rule 608. Those are federal rules. Rule 401 is going to test for probative, right? If the evidence is probative, means does it prove a fact? Does it prove elements? So everything you run down there and give the state or whatever may stop right there at 401 because it may not be probative. I'm not going to give the rest of it because I want motherfuckers to crash and burn. If you missed it way back in the day when I was going through it, you missed it. Then you got Rule 402. And those are the three R's. Is this evidence relevant, relatable, and reliable? Now, Oh, wait a minute. I'll tell you the beauty of shit. Let me write this down 'cause I'm going to forget because I'm old. Okay. Then you have 403, right? Now, 403 is where you start excluding evidence, okay? Because it may be deemed prejudice, a waste of time, confusing to the juror. Remember in the YSL trial, you heard a lot of 403 and early on, um, when we started covering the YSL trial, I said, oh boy, this is going to be a lot of 403 um, evidence. There are going to be a lot of motions with regards to 403. So when you go, then you go to Rule 404, which is the character evidence, right? Bad acts. When we're talking about 404, this is when they try to exclude the evidence because the bad acts you can't under 404, right? You cannot submit evidence that shows a defendant's propensity to commit a crime, that particular crime that they're talking about in the instant case. So that's when you start to see 404 popping up. It's going to be excluded if the judge determines that the evidence shows a defendant's propensity to do a crime. However, the evidence can be included if it proves motive or something like that. Then you have the Rule 608, right? That is character evidence. The evidence that when you think about someone's credibility and character and whatever, that's a Rule 608. It's different from Rule 404. Rule 608 deals with someone's credibility, right? That's when they try to impeach them on the stand. That's when they use Rule 608 evidence. Okay. Now, I'm not going to go into it too deep because I'm just not going to go into it too deep. It's all about strategy, baby. Now, the state could very well possibly think that they have a case based on what the evidence that have been submitted to them, right? That goes into discovery, and here's the thing, right? When I was teaching, I always broke up discovery and evidence for a reason, which is this the same thing, but I broke it up for a reason, right? Because I wanted to show the steps, how something gets submitted alleged proof gets submitted. I call that discovery. And then once it's admitted during a trial, I then call that evidence. Because everything that's submitted isn't always used, right? Sometimes it gets precluded, sometimes it gets excluded but due to one of these rules. So it doesn't always make the trial floor. That's why I broke it up. Remember, I never did litigation. I was transactional, meaning I'm in the office. I was the attorney that tried to prevent from cases going to court. So I'm cutting deals. I'm doing that type of stuff. I'm looking at legal contracts. I took the easy way out. Less money, but I had benefits. I ain't had to look for no clients and all that type. I wasn't doing all of that. Okay, when you are a litigator, you have. That's why you see a lot of attorneys turn to being ambulance chasers because you have to get your clientele through word of mouth or some shit like that, right? So you have to, you know, handle a bunch of cases, right? Everyone knows that being an ambulance chaser, 8 out of 10, you're going to win something for your client. That way you can build your clientele that way. Okay. And then, and sometimes a lot of lawyers do ambulance chasing just to keep the lights on, but they may very well be criminal defense attorneys. So you got to have, a name or whatever. If you have been successful defending drug um, clients that have been charged with something dealing with drugs, get your name up in that game. Sexual abuse, get your name up. So, and remember, you're competing against other attorneys. Anybody got time for that? When you can go work for a company or you can work for the government, get a check, get benefits and stuff like that. My main focus always has been taking care of my child, making sure we had insurance. So what? I'm not gonna be a millionaire working. I ain't even want to be an attorney any goddamn way. So what? I didn't, gonna. I'm not going to be a millionaire doing it the way I do it. I ain't saying I ain't never made $1 million. I'm not saying that. But like with Johnny Cochran and those litigators like that, they get those cases because of their name. The Garagos of the world, the list goes on. A lot of times, who you see them defending? High-powered clients, celebrities, people that can afford to put down a few million. But you talking about, you got students like me, went to a small school that would accept students like me, barely made it in, even at that, and barely made it out. If I'm gonna lie about it, hell, I tell you, oh baby, only thing I did well, and I couldn't even, I wouldn't even, not that I wanted to, I wasn't even pick to be on like the peer review and shit. Like the little news, pretty much a newspaper type of thing that a lot of law schools have. Most of them anyway. Uh-uh. One thing I'm known for is being a debate champ. Because you know your girl can read. Your girl can go off, right? So we traveled around and, beating people's asses in debates. Okay. So that's what we did. But anyway, you and the rules of evidence was my favorite part of school, right? The rules of evidence had been out about 20 years, right? When I started studying it, right? My favorite part of school. And there was an attorney that was on Sylvia's panel. She said, like, once you graduate school and you move towards your specialty, you pretty much forget all the other parts of the law. That is true. That is true, true, true. When you sit up there, all the thing you have to do is draft contracts or deal with the legal wording in companies, like disclaimers and stuff like that, coming up with all of that. That's easy. But it's just certain things that you can recall, from memory. So, but anyway, as I was saying, the state believes that they have a case, right? Hey, Queen. Hey, you. Hey, uniquely made. Hey, Pumpkin. The state, they have a case, right? They don't think they have a case because they did an in-depth investigation. They think they have a case because they're looking at what all they have. They have to verify that information. They have to verify that evidence as well as the defense. During pretrial, we've seen this. They settle disputes over the evidence that's been turned in. When it hits this discovery, it's going to be considered either exculpatory or inculpatory. If it's exculpatory, that means that it favors the defense. It has to be turned in due to Brady, to Jinx. We went through that, right? If it's exculpatory, then that means that it proves the state's case. But it gets investigated by both sides. They're not just taking your word for it. Okay, the state has to rely upon your evidence. Okay, that's one. And or the state has to rely on the evidence that they uncover. The only way they're going to do that is to do what I keep repeating, and I keep repeating because I want to get in your head. The only way that they can know what they're saying, know what they have, know what to use is that what they investigated. They're supposed to do that anyway. You heard Randa say that, um, scratch that. When they secured a warrant for Sylvia's arrest, it was just based on probable cause. Again, damn near the lowest standard. That investigation, if they did any, would not be nothing like the investigation that they are doing now, or are going to get ready to do in preparation for their case. They didn't ask or answer anything about the evidence with regards to the rules 401, 42, 43. None of that. Nor was her defense counsel there to submit what he has to counter what they have. This is now going to be the process. When they offer um, pleas and things of that nature, when you saw that her attorney said that he turned it down, he just was letting her know. That told me a lot. That he knows that the state is going to find out. He's going to help them find out. And they're going to drop this goddamn madness. Because usually, because listen, and I'm just going to be 100 with you. Lawyers on both sides, 9 out of 10 times, or 8 out of 10 times, know each other. They speak to each other. They have a rapport with one another. That was a good deal for somebody that's guilty. But if he turned it down like that and let her know he turned it down later on, he spoke on her behalf. Because it was probably a little whispering or something at the podium between the state or whatever. And he went ahead and shot it down and then text Sylvia and let her know. Right, Queen. Yeah, when we do that, we just want to clear the books. And it is so funny, and I ain't gonna put nobody business out here, but just about 3 or 4 days ago, this person was talking to me about their particular situation. And said, "Did you come out?" And then come out, and the state didn't. About 20 minutes before the court started, they just looked at the case. And I said, you know what? I had said that a couple months ago. I had said that a few days ago. And when you get the folder, open it up, look at that face sheet, and then give a recommendation. They still haven't done the pretrial taking care of the pretrial motions and things of that nature at that point. Meaning they haven't really looked into their own case. All the cases that we observe, we watch and what have you, and you see these people to go through pretrial. That should tell you right there that there's more that has to be done. Okay, you offer a plea because you just want to get it off your thing, and you want to, because that counts as a win. It's insane, right? And then you have that insane Audra, this woman is crazy, who had a plea and went to trial, and she was actually guilty, over some dude or whatever. It's insane. But the bozo actually, he talking about, I'm ready to go to trial. Dude, it's not your case. You are a witness, a victim witness, alleged, heavy on the alleged. And this is the beauty of it. This is the beauty of it. All that shit he keep running down there, putting in discovery, the damn defense gets to use against him. Oh shit. The defense gets to use it against him. It's called exculpatory. Hey, CMT. Right. This is crazy. They get to use that evidence against the state. They got to poke holes in it. And I'm telling you, if everyone does their job, this shall be over quickly. It shall be over quickly. And he'll just come up with something else. Cannot take the L, honey. That's just crazy to me. And let me tell you what this experience I have taught me. Yes, ma'am, CMT. Yes, ma'am. Always. So it is unbelievable that people, as long as we've been in this sector, going through this, and God knows I have broken down every. Oh my gosh, some people are still telling me, saying, Miss Angela, I feel like I'm a paralegal now. After listening to you or whatever, and I appreciate all the compliments. Thank you, thank you, thank you. Right. But it is just, it is mind blowing for someone to think that they are just going to use everything you bring down there. Like, huh? But I'm glad that he keeps bringing stuff down there. I really am. And putting people on the witness list that don't know their witnesses and shit. Like, that's crazy. Queenie, the way his psychology is set up is that once this mess is over, he gonna try to involve in something else. Just insane. This is what I learned, right? From dealing with these people in this sector, good or bad. This is what I learned. I thought this early on, right? I thought that people, that you encounter in this sector, what have you, would be much like the people you encounter in everyday life, regular everyday life, right? Just normal people. You have casual acquaintances, just, nobody's trying to do all this extra shit to you. Nobody is trying to get close to you to do something to. I have this. I don't know. Yeah, that's what I thought, because normal, regular, everyday people, they don't do all of that. They don't try to get you in and put you in jail and all this extra shit, lie you all up or whatever. I don't fault people. I definitely cussed a number of them out, and I have a whole heap of friends. I have a whole heap of people that know me that I don't even know, because in some of those disagreements, it's about all of them, we were able to get beyond it because we were reasonable, rational thinking people. They lost the fight, they just lost the fight. We're able to have carry on normal behavior, meaning even in some of those times when we get fallen out or whatever, there have been terrible things that have happened, right? While we were not speaking or whatever. But we were able to pick up the phone or pop up or whatever to check on one another and didn't feel a way about it. Didn't feel like, oh, it's something behind it, or, maybe I'm being, recorded, or all the extra shit, right? We were able to be ourselves, who we really are, who we naturally are, right? If someone needed help, not a problem. You didn't have to harden your heart or whatever. You didn't have to think that someone was out to get you, or you got to record this and what I mean record, I'm talking about stream record these videos and stuff like that. You had to do all of that. That's crazy, right? But you have to do it for protection. Protection from the YouTube streets. That is insane to me. You have people that, y'all, listen, I lay this shit out on D-Day. Y'all gonna be like, oh my. Y'all gonna be surprised. Like, who does this type of shit? And who supports people that do shit like this? It is absolutely insane. Absolutely fucking insane to me. But it has taught me something, right? Because I just, happy go lucky, had not been paranoid of people or whatever, snakes and things that I ain't never in my life had nobody befriend me just to do some shit to me or do some shit. Never, that has never happened. Not to here. That has never happened. The only thing this experience did was make me look at people differently. I met a lot of people online, right? A lot of people online. And some because we were in some heated stuff, right? Meaning like debates about politics or stuff like that, right? Let me see what this lady said. Okay. Hold on. I'm sorry, y'all. I'm answering something. As a matter of fact, I am responding to one of the ladies that I met online, right? I'm responding to her through another app. But I met so many people, and it was never no kind of craziness like this. So y'all know I have those disclaimers. I don't think I have to put the disclaimers up now, but y'all know when I'm operating under disclaimer number 2. So when I say y'all are some of the worst motherfuckers on the planet, I'm not talking about all of you guys, right? Definitely not the people in here, okay? But the example of it is of what I'm talking about is unbelievable. Who do this type of shit? And what do you do? And you gain nothing? You're just doing it because you just don't have nothing to do? Like, huh? Or they want to know who you are. Just ask. I don't know. I don't get it. That's what I'm saying. It's a lot of craziness, whatever. But I told you that a lot of these people haven't experienced some, the beats. Let me see. Right. I mean, like, uh, I mean, think about in your life of the people that you done had arguments with and what it was about. And I guarantee you, half of it, it didn't amount to nobody doing no shit like this. The shit these people do try to do to you. It is insane. But I tell you what, this shit has made me look at people totally different. Uh-uh. Baby, you gonna have to come with a goddamn somebody gonna have to refer you to me. And I need a referral just for us to be cool. Yes. Uh-uh. 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 They were like, Andy, what's wrong? Uh-uh. They ain't gonna believe it. Uh-uh. Uh-uh. And while I can laugh and smile and still be cordial, not even cordial, just be we existing in the same area because you don't affect me. You can't. There's nothing you can do to me. I don't even know you motherfuckers. Be honest. You still trying. I've already done it. That type of shit, right? It's just weird. It's a lot. I have a little paranoia now. I'm looking at people sideways, honey. I don't know. I think people on DL. I think there's a lot going on. And that's ain't none of my business. That's cool, but I'm just saying. Don't say you ain't when all arrows pointing at you. Just a bunch of shit going on. And people minding other people's business. Who does that? I tell you, a bunch of no good motherfuckers. It's like I'm minding my business and so are you. Well, like when you minding my business, who was taking care of your business? Shit. But y'all, I'm gonna tell you, once this shit, once it gets down to the nitty gritty, oh baby, cause I told you, both sides gotta ask questions. And what I mean by that, not only questions of each other, they got to ask questions of their own case. People just don't go in there based on what you goddamn tell them. They ain't that goddamn dumb. We gonna have us a good goddamn time laughing. I promise you that. We're going to laugh our ass off. And I just want them to put something down where this can't happen again. Because this is, it's disturbing. Hold on, I'm trying to. It's fucking disturbing. But yeah, I don't want this to ever happen a goddamn again. Right? They need to block some people from filing any goddamn thing because you weaponizing the court. Just like that Cordello Smith guy with Diddy, he done sued every goddamn body. And he's nuts. Let me see what y'all talking about. Hold on. Crazy. Yep. No one could answer me today how Dallas wasn't told that when the police showed up that Sunday that Infinite City has a warrant. Why wouldn't they tell Dallas that if they didn't in fact have the house swatted? Well, they should have told her that there was a warrant. They should have told her that. The time in the storyline is not adding up from the state's case because stuff isn't. Yep, bingo. Because, see, that's a part of preparation in their case. They got a story to tell. They have to tell a story. Now, watch Bozo think he's so smart, gonna take what I'm saying and go run down there and listen. I'm not gonna give you the all the plugs. Not keep running down there. They got a story to tell. They got a timeline format to tell it in. Evidence have to be in compliance, in accordance, be admissible under all those rules. The defense gets to challenge the little shit that the state wants you, because I'm thinking little shit, right? Because I'm pretty sure everything that's been submitted, probably only a handful can be used, and the defense is going to challenge that. I don't know who thought this, who came up with this shit here. It's just unbelievable, unfucking believable to me. This was not a good idea. This was not a good fucking idea. Oh, let me get back to your comments. I'm trying to save something. I just don't understand how people think they're going to get away with this. No, baby. that if they was just coming to serve a warrant, what did she miss to be warranted for the arrest? Um, she said court probation, first appearance. I mean to show up on a Sunday night to serve a warrant. That doesn't sound. Um, oh, you familiar with Audra, huh? Keefe and Audrey M going to come and say you an informant. Yeah, she's already said that. Off her rocker today. I know someone giving him bad advice. No, that's him. Oh, he's driving that. Ain't nobody giving him no kind of idea, no kind of advice or anything. Yeah, she familiarized herself today with the chat hopping. It's wild. Yeah. So once they've established probable cause, then a warrant can be issued. So it's nothing that they have to. She don't have to miss court or probation or anything like that. He went down there and made a complaint, pretty much a complaint warrant. The judge signed it, and they had a warrant for her arrest. What I'm saying is, that's fine. People get accused for doing shit that they didn't do every day. Somebody stole my identity. Actually, it was two other girls, and our shit was all crossed up. I had to walk around with paperwork with me for years afterwards, because this girl hadn't done the most and was doing the most. I wish my mom was alive, or I was in contact with one of my set of inmates, Lord, in-laws, where they, where I was literally, what had happened. Well, I'm tell you what happened. I had gotten into it with the apartment complex, right? I had gave her a deposit, whatever. It was, one of the more, um, one of them areas where if you look like me, you're going to be scrutinized a little bit closer, right? I couldn't understand what was the issue with what was going on, because everything had checked out, you know. So I just had a funny feeling, about the apartment complex. I don't want to stay nowhere where they're not nice to everybody, right? And what I mean, not kissing nobody's ass, but like, I know everything was a-okay, but you told me everything was a-okay. But when it came down to, because I had, I had already picked an apartment, and it was just a whole bunch of shit. You could tell that when I talked to one person in the office, that person was, nice and whatever, and everything. And then when you talk to the other person, you can kind of tell. You can kind of tell that. So I don't want to stay nowhere like that. So get my motherfucking deposit back. My lease is almost up at this other place. Get my deposit back. I can put it on some, I can get somewhere else, right? They wanted to hold up the deposit. 9 grand. And the deposit was like 250, something like that. When I started asking for my money back, they act like, they don't want to answer the phone, all this extra shit. Then when they do get on the phone, they're going to say, um, we mail it to you within 30 days. Huh? I ain't really want, and I ain't really wanted to deal with that. And by that time, I hadn't had an attitude anyway. So you're going to get cussed out regardless. You're going to get cussed out. Chat. Tell you how they try to set me up. I told you this girl. This girl lives, and the girl with my name lives in Tampa, Florida. That girl was either born in '66 or she's 6 years older than me. It was something with the six. Oh, I forgot what it was. But she lives in Tampa, Florida. By the time the apartment thing, I got candy in my mouth. I'm sorry. By the time the apartment thing had done happened, we had done went to court and everything. Okay, so and here's the thing, right? The judge didn't know what to believe, whose account belongs to who, which one actually opened. It was crazy. Okay, it was cray. So anyway, I just had to walk around with the paperwork for a while. So let me tell you how they tried to set me up, because I did threaten to come to their office and beat their ass about my money. I did that. So all of a sudden, the lady called me back and said, "What?" She said, "Okay, you can come to the office and get the money. What time?" I gave her time. Now I should have known right then that this was a setup. So I go to the office, I get the money, I pull out, and how the complex is made. I mean, when I tell you, beautiful landscape on the water, palm trees in a circle, just beautiful, right? And because it was right next door to my job, listen, I mean, at that time, that area was Bay Meadows was the area to stay in, but that was about 30 years ago. Yeah, yeah, about 30 years ago. Beautiful, honey, ducks and pelicans and all that shit they had over there. Okay, I get the check. I proceed to come out. Here come the police behind me. I wasn't doing breaking no speed thing. And by the time I turned out on Bay Meadows, he had the lights on, pulling me over. I had done nothing. I was like, yeah. I was on the phone with my mama. He brought his ass to that goddamn window. I'm like, yeah. He said, um, can I have your ID or whatever? Sure. So I got his badge and I told my mom, I say, call my in-laws, which I told you they were police ass family, right? Call my in-laws. She called my mother-in-law, which called her daughter, one of her daughters. They ran the cops badge and stuff. They say he is off duty. So I guess he's doing an off duty job for the apartments. He trying to figure out who I'm talking on the phone that knows his goddamn business. Like, don't worry about it. Cause time I leave here, I'm going out here to put a complaint in on you. So the dude tried to make me be the girl in Tampa. Cause she had, and when my ID, the ID number and all that, my driver, all that shit says I'm not that girl. He tried to make me that woman. Baby, I was like, he wanted me to get off the phone. It was crazy. It was crazy. I was like, mm-mm. So that shit there, that whole arrest and how they do that shit, whatever, that shit that is don't sometimes don't even be accurate, and you have to go through the process and appear before a judge to try to get that straight. That is crazy, right? Mm-mm. But yeah, hey Pamela. So if it gets thrown out for return fees, she familiarizes her today with chat habits. Wow. Girl, yes. So that Audra, oh my gosh, y'all, I did a whole breakdown on her. How she had done worked up that attorney. That man was so goddamn, he didn't, like, what? He couldn't believe it. And two times it was on her paperwork, and she gets mad at me because I did a study on it. I mean, it's the law, and we also do psychological studies over here. Shit, if if you qualify for both and you're in this sector, hey, she the one put it out. But the videos anyway. She was trying to prove her case. And all it did was prove that she was in the wrong. The 911 call, the poor lady and the man in the background sounded desperate. She had to hit that lady in the head with a shovel. Audrey don't have a clue as to what she's talking about the case, about none of it. She's so far behind just because she can't find a marriage certificate, whatever, about with Aaliyah and R. Kelly, some kind of way. I have no idea what that means in her head. And I'm telling you, although she sounds like she's intelligent and outside of specializations like the law and medicine, things that's involved in science and stuff like that, right? you may be able to just read something and recite that very well. That doesn't mean she's not crazy and that she doesn't understand the law to the fullest capacity, or to at least even to the mid capacity, right? Or medicine, or some of the other specializations that you will run across out here when it comes to a profession. But she sounds like she knows what she's talking about. But I know she does not. She's somewhere in the bushes laying around. So but she hit that lady in the head. And on her YouTube channel, she got her last name as the same as the dude who was on the 911. I don't know if they was together, and I had the transcript, but um I forgot what they said when they took the stand. That's crazy to me. Like the stuff y'all do for these men, babe. Mm, 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 mm. I can't. It's frustrating because when these men run into a person like me, they think I'm difficult. Huh? How am I difficult? Like, mm-mm. You have people, girl. Anyway, so let's move on. Because we can talk about this foolishness all day and every day. I miss this lady. Y'all, also, well, some people ain't ashamed of their sector, but I am. So, baby, I don't know how this goddamn AI and this shit is working with all these apps, and all of this is just much. It's overwhelming. But my regular apps, the Instagram, whatever, is getting confused with this stuff. I'm turning stuff off. I'm canceling. I'm deactivating and stuff. It's crazy, and I think it's that goddamn Facebook, y'all. I don't want to accept no cookies no more. I don't listen, y'all. I'm not. I don't want you to do nothing with my. Don't use my contacts. None of that. I'm just letting y'all know, just in case y'all want to go in there and turn that stuff off or whatever, because these people stalk you. But I have no idea. And you notice I don't have an idea. This is crazy right here. How do people tell others don't talk to a person, don't go to their channel and all that shit when they turn around and do it themselves? How you gonna tell somebody else don't talk to me and you talking to me? I don't understand none of that. That's crazy. And they try to convince you that you just paranoid or you just making up shit or you just none of this shit is going on. When it's like, but yes, it is. I've got evidence that it's going on. That's weird. Just weird to me. Yeah, but y'all don't be talking about sinking contacts because you just think it's easier or whatever. Don't be I don't want to. I don't even understand. I'm gonna have to look up what accepting cookies even do. I don't accept no cookies no more. I don't do none of that. Can we share your little no? You can't do shit. Now I do it manually. I don't need you to do nothing. When I started seeing my real people popping up in my face, oh no. Nope. Anyway, y'all, we got to lay some stuff down on the record. So I think I want to go with TK first, right? We want to put him on the record, right? His case is over. He was found guilty. Don't know what was said, but I know I have the his verdict as well as his penalty phase. So I have him. I'm going to put him on the record.
On the record in 2019 CR 12495 State versus Tamar McIntyre. Could I have parties announced for the record, please?
Jason, go ahead and make a galley with your state, Your Honor. John Hunter Thomas Lane for Mr. McIntyre, Your Honor.
All right. It's the court's understanding from the deputy that a verdict has been reached in this case. This is what I'm going to tell all the parties who are present in this courtroom. There's not to be any outbursts. If there's an outburst, what's going to end up happening is a deputy is going to tap you on the shoulder. There's no need to get into a conversation with the deputy. That tap on the shoulder is meaning that you are to leave this courtroom and you will only be allowed back in this courtroom if you're going to be a witness. Does everyone understand?
Yes, sir.
Is there anyone who cannot do that? So both parties for the state and the defense, if you need to talk to members who are currently in court that are either with the state or defense, you may do so now. Otherwise, I'm going to bring the jury in.
I think everyone knows to be on their best behavior, Your Honor.
All right, let's bring the jurors in.
All right, for the jury.
All right, everyone, please be seated. All right, ladies and gentlemen, it's my understanding that you've reached a verdict in this case. Is that correct?
Yes.
And is that verdict unanimous?
Yes.
All right, if you will give the verdict form to Deputy Laura, please. Thank you. All right, if the defendant could please stand. We, the jury, find the defendant, Tamar McIntyre, not guilty of the offense of capital murder. Excuse me, no. No, out of the courtroom. Out of the courtroom now.
Yes.
All right, ladies and gentlemen, you don't ignore that. Sometimes, as you can tell, people are invested, correct? So it says, we, the jury, find the defendant, Tamar McIntyre, not guilty of the offense of capital murder as charged in the indictment. We, the jury, find the defendant, Tamar McIntyre, guilty of the lesser included offense of murder. Does anyone wish to have the jury polled?
Not the state, Your Honor. Yes, Your Honor.
All right, ladies and gentlemen. And do you want them polled as to both counts?
As to the count of conviction, Your Honor.
All right, you may be seated. Ladies and gentlemen, I'm going to ask you if, in count 2, the guilty verdict for murder, if that is your verdict. If that is your verdict, I'm going to need you to respond yes. Does everyone understand?
Yes.
So we'll start on this end and work our way down. Is this your verdict? Is this your verdict?
Yes.
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 Is this your verdict?
They're alternates.
Oh, yes. All right. Back row.
Yes, sorry.
Is this your verdict?
Yes.
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 All right, ladies and gentlemen, what's going to happen now is I'm going to allow you all to have your recess for lunch, and then we'll begin the second phase of the trial. All right, everyone, please rise for the jurors.
Wow, so they had found him guilty of the lesser included charge, right? Now with that, even though it's a lesser included charge, the jury still had to have found that he committed the elements, right? That he was charged with. Oh yeah. I'm texting something. Okay. All right. So you see, he was found guilty of the lesser included. So now I had this all.
So we'll come back at 2 p.m.
Hold on. Okay. Let's watch it from another view, and then we can go right into the penalty part of it.
All right, everyone, please be seated. All right, ladies and gentlemen, it's my understanding that you've reached a verdict in this case. Is that correct?
Yes.
And is that verdict unanimous?
Yes.
All right, if you will give the verdict form to Deputy Laura, please. Thank you. All right, if the defendant could please stand. We, the jury, find the defendant, Tamar McIntyre, not guilty of the offense of capital murder. What did I, excuse me, no. No, out of the courtroom. Out of the courtroom now.
Yes.
All right, ladies and gentlemen, you don't ignore that. Sometimes, as you can tell, people are invested, correct? So it says, we, the jury, find the defendant, Tamar McIntyre, not guilty of the offense of capital murder as charged in the indictment. We, the jury, find the defendant, Tamar McIntyre, guilty of the lesser included offense of murder. Does anyone wish to have the jury polled?
Not the state, Your Honor.
Yes, Your Honor.
All right, ladies and gentlemen, and do you want them polled as to both counts?
As to the count of conviction, Your Honor.
All right, you may be seated. Ladies and gentlemen, I'm going to ask you if, in count 2, the guilty verdict for murder, if that is your verdict. If that is your verdict, I'm going to need you to respond yes. Does everyone understand?
Yes.
So we'll start on this end and work our way down. Is this your verdict? Is this your verdict?
Yes.
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 Is this your verdict?
They're alternates.
Oh, yes.
Alternate.
All right. Back row.
Yes, sorry.
Is this your verdict?
Yes.
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 All right, ladies and gentlemen, what's going to happen now is I'm going to allow you all to have your recess for lunch, and then we'll begin the second phase of the trial. All right, everyone, please rise for the jurors. All right, everyone, please be seated. So what we will do is I think if we all come back at 2 p.m., that should give everybody a chance to have whatever witnesses they need to have present. So we'll come back at 2 p.m. for the second phase of the trial. All right, thank you.
Okay, we're moving on to the penalty phase. I'm sorry, I need to be nosy. I see what they're talking about.
Judge, just for housekeeping purposes, how would you like us to mark exhibits for punishment? Do you want us to continue with what we had in the case of chief, or would you like us to go like P1, P2? Or
You can do states P1, P2.
P1? Okay.
Yes. But just do, states P1, P2.
Yes.
I think it makes it easier for
Yeah.
the Court of
for
Appeals.
appeals and everything else.
Is a witness, any witness going to be called who's going to be able to say to this jury that stacking or not stacking is completely up to the court? If there is not going to be a witness, then we can take up whether in closing argument or however you want to let the jury know that the court is in it's the court's authority to decide whether a case is run consecutively or concurrently, we can take it up at that point.
Right, because, I mean, fundamentally, it wouldn't be a witness, it would be a charge to the jury.
Okay, so we on the record. And defense, it's my understanding that you are going to be requesting a hearing outside the presence of the jury on the witness's expertise.
Well, Your Honor, before we do that, I guess if I can take up a collateral matter that
Sure.
informs this decision.
Okay.
Before the trial started, maybe several months before the trial started, the state filed a motion advising that they would be asking Your Honor to stack the sentence in this case with the sentence in Fort Worth. And obviously, that's a matter we will be taking up after the jury's verdict on punishment. But I wanted to make sure that there was no issue with liability to argue that that motion was in play. In other words, to apprise the jury of the fact that there is a petition by the state that whenever sentence is returned in this case be run consecutively.
Well, I don't think that's going to be discussed with the jury because it's not their decision to make.
Yes, Your Honor, but I think that there's some authority that suggests that unlike parole or matters like that, the jury needs to be aware that the court has the discretionary power to stack the sentences because
No.
if I could just, there are a couple of cases I think that
Sure.
maybe call at this point. And I'll read them into the record real fast. The first is Vargas versus State, Bargas, 252 Southwest 3rd, 876. That's Court of Appeals, 14th District of Houston, 2008. And Halliburton versus State, Haliburton, Court of Criminal Appeals, 1979. And in these cases, there's discussion about, in one instance,
Well, let me stop you for a moment, counsel. So here's the question. Is any witness going to be called who's going to be able to say to this jury that stacking or not stacking is completely up to the court? If there is not going to be a witness, then we can take up whether in closing argument or however you want to let the jury know that the court it's the court's authority to decide whether a case is run consecutively or concurrently. We can take it up at that point.
Right, because, I mean, fundamentally, it wouldn't be a witness, it would be a charge to the jury.
Okay, so we can take that up at that point.
But I would like to talk about it in opening. I won't if we haven't ruled on it yet, but
Yeah.
I think that because the law seems to indicate jurors are entitled to know, I thought it would be best if we could talk about it in opening, and I wanted to give you.
We can take it up in closing. I think that would probably be best.
Yes, Your Honor, I understand. Just a moment.
Sure.
We can go ahead and proceed with the hearing outside the presence on the fingerprints, Your Honor.
Okay. All right, and so it's the court's understanding this is simply going to be a hearing.
We should proceed forward.
All right, so my understanding, this is just specifically a hearing to make a determination on whether or not the witness that the state is calling as, I'm assuming, a fingerprint expert,
Yes, Your Honor.
whether or not they're qualified.
My challenge would be to their qualification, and I would challenge the science of fingerprinting generally under the Daubert-Kelly standard.
All right, let's bring them in. State, call your witness.
State prosecutor on this.
All right, if you'll take a seat here, please. All right, if you can raise your right hand for me, please. Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you can lower your hand. If you'll put there should be a little clip, a square.
Mhm.
If you'll put that on your lapel or somewhere, it's for the court reporter. All right. And Cindy, I am trying to go to your link. And let me see, it may not be working. Just one second. All right, have it. Thank you. All right, if you'll state your name and spell your last name for the record, please.
Mia Valdez, last name Valdez.
All right, you may proceed.
Thank you, John. Ms. Valdez, can you please just tell us what's your occupation
I'm a fingerprint examiner for the Bexar County Sheriff's Office
and how long have you held that position?
for 2 years.
And how do you have to go through certain type of training?
Yes.
What type of training is that?
Yes, we go through a 2-week course to learn and identify as well as classify fingerprints, and then as well as on-the-job training.
And so you said 13 years?
2 years.
I'm sorry, 2 years?
2 years.
Okay, 2 years. And this the training that you are having on the job, is that every day you come in, is there certain criteria they have to meet, or how do you go about your daily duties?
We typically review the fingerprints of every inmate that is brought into the jail.
So numerous.
Correct.
And have you ever testified in Bexar County before,
Yes, sir.
associated with fingerprint?
Yes, sir.
And what is a fingerprint?
A fingerprint is an impression made up of characteristics that is used for a means of identification for an individual.
And can you describe what an inked print means?
An ink print is typically used with an ink pad as well as an ink print card that is also an impression of a means to identify an individual.
And these unique characteristics, through your training and experience, have you ever come across or known of anybody having the exact same fingerprint?
No, not in my experience.
And so when you say unique characteristics, does that mean fingerprints are unique and identifying for every individual?
That is correct.
And is this something that's accepted across your line of expertise as an examiner?
Correct.
And can you just describe briefly the different characteristics of a fingerprint?
Oh, so typically they have 12 different characteristics consisting of ridge endings, bifurcations, item ridges, and multiple characteristics.
And so, fingerprint is
Yes.
How are you?
Great. How about yourself?
I'm well, thank you. So, in terms of what you have been called here today to do, were you asked to give an opinion about comparison of fingerprints?
Not an opinion, so per se, but yes, to identify fingerprints.
Okay, now, when you say not an opinion, you were asked to look at some inked fingerprints that you did of Mr. McIntyre here in this courtroom about 15 minutes ago, right?
Correct.
And you were also asked to look at what I imagine was a drop card that had been taken on a previous day.
Correct.
And that drop card, did it contain any information on it, or was it just the fingerprints?
No, it is a part of the booking sheet, so it had name, date of birth, and other identifiers.
So it was a booking sheet.
Correct.
It was not a judgment.
I was reviewing judgments, but there was also a booking sheet.
Well, did you compare it to the booking sheet or to the judgment?
Both.
You compared it to both the booking sheet and the judgment.
Correct.
Okay. And those things obviously had a name on it.
Correct.
Associated with both the judgment and the booking sheet.
Correct.
I guess it was the same name.
Yes.
I gather you're going to testify that name was Samuel McIntyre.
Correct.
And you believe that that's the same individual that you just took prints of?
That is
today,
correct.
correct? Okay. So, to be fair, you were not given anyone else's fingerprints to compare it to, right?
No, sir.
And you are aware of why you're here and what you were called up today to do, right?
Correct.
You're aware of this trial generally.
Correct.
And so the prosecutor was asking you this specific question in the context of being able to prove up a prior judgment for sentencing.
Correct.
Okay. And you have not given the work that you did in this case over to any other examiner to see if they could check your work.
No, sir.
Okay. And that's not a common practice that's done by your department in these kinds of situations with inked prints, correct?
Correct.
Okay. Now, you talk about the unique characteristics of an individual that appear on their fingertips that would leave these telltale markings, right?
Correct.
Do you know if what scientific work has been done to confirm whether or not that is a universal truth about the human condition, that every single human being alive has genuinely a completely different fingerprint?
That is not a part of my department to research that.
Okay. Do you know whether or not there's been any scientific research done to determine whether people's fingerprints change over time?
No, sir.
Okay. Do you keep up with any literature in the field discussing potential problematic areas in fingerprinting or places where a fingerprint examiner might make an error?
Yes, sir, I have.
Okay. And are you aware that errors can be made in fingerprint examination?
Yes, sir.
Can you talk to the judge a little bit about the ways that you've been trained to look out for errors and mistakes?
In terms of mistakes, there is multiple reasons. It could be unable to read a fingerprint due to scarring, burning, or anything of that matter. We also encounter amputees to where we don't have a fingerprint to discover. And then as it changes over time, it does become a little bit more difficult to read the fingerprint.
When you say as it changes over time, you mean as a person gets older?
Correct.
Okay. So fingerprints that were taken when someone was 17, 18 years old may be different than they are when they're 25.
No, not necessarily. It has to be like a wide age gap.
Okay. You say not necessarily. I mean, you can't speak specifically to how many years it is before someone's fingerprints might show different characteristics.
Not a specific number, no.
Okay. And admittedly, what you're doing here is you're looking at the exemplar print, and you're looking at the print that you're asked to compare that to, and you're eyeballing visual characteristics of how the ink appears on the paper, right?
Yes, sir.
And did you make any drawings or rough notes or sketches
No,
to
sir.
document that?
No, sir. I just fingerprinted.
Okay, so it's just something that's in your head based on what you saw with your eyes.
Correct.
And so even if we had another fingerprint examiner here today to try and check your work, they wouldn't really know exactly what were the things that you keyed in on.
Correct.
They'd have to make their own independent evaluation.
Yes, sir.
Okay. Do you know of any other scientific discipline where the answer to your question has been predetermined in advance by the people asking it of you?
No, sir.
Okay. I'll pass the witness.
Any further questions?
No more questions.
All right, the court will hear argument.
Your Honor, I think that we don't have the Daubert-Kelly standard satisfied here. This is something that was done here in the last 15 minutes. There's been no attempt to check the work, to have it peer reviewed, to have it assessed by anyone else. The witness is not fully familiar with all of the literature about the potential pitfalls of comparison. The witness does not have any documented example of the work that was done by the visual examination conducted here in the courtroom today. So there would be no way to independently criticize that work or vet it, because the next person we bring in would just themselves have to do the exact same visual eyeball observation. So what we're doing here is we're asking someone who has a 2-week course on identification that talks about the basics and 2 years of on-the-job experience, looking at print that they've been told in advance is likely belonging to the same man that was fingerprinted in the courtroom, and giving a confirmatory example. That's not a scientific pursuit, although it is a question that touches upon scientific evidence. And we know, both from popular culture and from just the way that we verbally discuss the concept of a fingerprint, that people do place undue emphasis on what a fingerprint
So
can
you're
tell you and
saying
what it cannot.
that the state told her that this is the person and this is their fingerprints?
I think that was the witness's testimony.
No, I'm just saying, is that what you're saying?
I believe that's what the witness testified to.
All right.
I think that is definitionally unscientific. and that it should not be admitted under Rule 702 or Dauber and Kelly, and that does have inherently a due process component to it. And so we would object to the testimony.
All right, state response. He said that you told the witness who the fingerprints belonged to.
We want to know. We asked her to compare the person that she had fingerprinted today with the fingerprint, and she did that, and she identified that it was the same person that she just fingerprinted in court. The underlying validity of this technique has been applied properly, and she has the experience and the training to be an certified or a fingerprint examiner. So the state's position is one. In a sense, defense is saying that the state has asked somebody to lie on the stand, and I take offense to that.
That is not what we're saying. And you know
Well, I
that's
mean,
not,
in a backdoor way, Judge, that's what you're saying, so I don't
it's not even
appreciate
in the
that.
backdoor way. No, that's not what we're saying.
All right, so here's the thing. We cannot speak over each other. I'll let the state finish, and then defense, I'll allow you to respond.
So, Judge, at another premise that we asked an individual to come up on the stand and identify somebody just for the reasoning of having a fingerprint match. The state is not in that position, would never put themselves in that position due to ethics and also following an oath that has been taken. So in this particular case, Your Honor, the state simply asked Mia Valdez, a fingerprint examiner for the Fair County Sheriff's Office, to see if she could identify a fingerprint that she identified the person that she took fingerprints in today, and then compared that to a judgment and identified that person as Trey Morgan McIntyre.
All right, now your response.
Your Honor, the testimony of the witness was that she was presented a booking sheet and a judgment. Now, perhaps the witness has those documents in front of her and would produce them as court exhibits so we can clear this up. But my understanding of the words booking sheet and judgment are that those documents contain the name of the defendant. The witness also testified that they are aware of this case and who is being prosecuted and what this case is about generally.
So you're not saying that the state told her that this judgment is for your client?
What I'm saying is the state gave her documents that contain identifying information on and asked them to.
Right, I just want to be clear because I need to make a ruling. So you're not saying that the state gave her a packet, gave her documentation and says, we're giving you this documentation. It goes with your client. So bring us this information.
I am not accusing Mr. Garahan or anybody else in the district attorney's office of telling the witness what to say
Okay.
or violating in any way their ethical obligations. And I'm so sorry that you perceive it that way. I can't fathom that that's how you perceive it, but I'm sorry. My purpose in making the argument is the witnesses testified that they reviewed judgments and booking sheets. I've never seen a judgment or a booking sheet ever that don't have the name of the defendant on them. And the witness also attested to the fact that they know who Mr. McIntyre is, or at least they testified they're aware who's on trial, which would give them the name of them. So, I mean, it doesn't have to be that someone went in there and said, now listen here, I need you to testify that that man there is Tamor McIntyre, he's the same man that's on this drop sheet.
Okay, so I understand your argument. So the defense's motion is denied. The witness will be allowed to testify. With regards to opening statements, you are allowed to let the jury know that the court makes the decision on whether sentences run consecutively or concurrently, the end.
Thank you, Judge.
All right, so if you can step down from the witness stand, I'm gonna bring the jury in. And let me ask y'all, does anybody have let me see if I have a copy of the indictment. I don't know, is there an enhancement in the indictment or no? So it's strictly from motions.
It's strictly to stack the sentences from the state.
Okay. And I'm assuming that your client is not pleading true to the prior.
Well, Your Honor, it's not, it isn't alleged in the indictment, and it isn't being used as an enhancement because it wasn't a final.
No, I understand that. But I'm asking, is the witness going to come and testify, or is your client planning on saying that he is in fact the person who has this prior judgment or no?
We're not going to plead true.
Okay, that was my question.
Sorry,
All right.
I'm sorry, but we're not pleading true.
Okay.
Judge, the witness took the mic. Is she the first witness?
Yes, she's the first witness. Nobody raised your sign that said do not take the mics. All right, so the advocate, can you make sure that the witness still has the mic and not to lose the court reporter's mic? Thank you.
We got it, Judge.
All right, thank you. Yes.
Judge,
Yes.
we're not on the record, but when we're on the record, we would just be opposed, the state would be opposed that this. We do have some case law available, Judge, if you like it, but I'd just like to just put it on this, the record.
All right, well, I will tell you, I know that case law says different things. I know that some case law said it's not an abuse of discretion for the jury to be informed that it's the court decision on whether or not the court is allowed to stack or to run concurrently. But what I'm telling parties, that is all you're allowed to say in opening statements about it, is that is within the purview of the court. So there's to be going into no other part of that. That may be something for closing, which you'll see. But in opening, I am going to allow the parties to say that is completely up to the court. The end.
Okay, Judge.
No expounding.
We can explain what a consecutive sentence is. That is an option that you will consider after the
And
sentence.
explain it in what way?
Judge, do you want this on?
Yes.
Okay, sorry.
Explain it in what way?
That you will have discretion at the end of this case to make a decision about whether their verdict should run concurrent or consecutive. And that consecutive sentencing means that this sentence will not begin to run until another sentence is completed.
Yes.
That's all I want to do.
All right.
And
All right, let's bring the jurors in.
All right, for the jury.
Hold on, y'all. I got knocked off. Hold on. Y'all hear me? Yeah, y'all can hear me. Okay, real quick. So, y'all see how the defense got to object to the state's witness. I think it was a question of whether or not she is qualified to testify to what she's testifying to. Yeah, everything has to go through those rules I was pointing out to you guys. Those are the main ones when it comes to evidence. And testimony is evidence. Also, to elaborate a little bit more, I think I told you, but so they found him guilty of the lesser charge, right? Which means that they probably didn't have enough to find him guilty of all the elements in the charges on the indictment, but in the lesser, they found him guilty. Normally, some probably at some point during the judge's instruction, she'll let them know that there is a lesser charge, or sometimes if the deliberation takes longer, the prosecutors may offer a lesser charge at that time. But usually the judge instructs the jury that there is a lesser charge, right? And if they can find the, and they are able, if they, if they can find that he is guilty of the elements of the lesser crime, then they can convict him of that. They were having a question with regards to stacking, right? And this is where you heard them, they're going back and forth with regards to should the charges run consecutive or concurrent, whether or not to let the jury know, and all of this, what all this, la la. And pretty much stacking apparently is an option that the judge has, meaning that he may have some charges somewhere else, or it could be charges, different charges in that particular case in that courtroom. And the judge has the right, if she would like to stack them, stack the charges, right? Meaning give them one blanket sentence for all of the charges that he was found guilty. You can run them consecutive. You got the choice of running consecutive or concurrent. What else do they say? Oh, I heard the defense say, well, that is he said, I think that's a charge given to the jury. And that just simply means that's the instruction that the judge gives to the jury. So he said, do it as a charge, meaning do it as an instruction to the jury. That's why it's called jury charge. Sometimes you won't always see jury instruction. You'll see jury charge. That is just a set of instructions that's given to the jury. What else? And of course, you guys know what discovery contains. It can contain Brady, Jinx, and Giglio evidence. We know what Brady is. Brady is evidence that is meant to be exculpatory, meaning that it can prove that the defendant is innocent. You have your Jinx or Jinx Act or 3500 material. Those are prior statements by judges, not judges, Lord, prior statements by the government's witnesses, right? All this must be a part of the discovery. Then you have Giglio, which is just evidence, impeachment evidence used to impeach the government's witnesses. And when I say government, of course, that includes the state. So I told y'all I'll just use government to reference everyone, every prosecution, right? So that those are the majority of the things that go into the discovery, right? All right, let's get back to what they were talking about.
All right, everyone, please be seated. All right, ladies and gentlemen, this is the second phase of this trial. Each party will have a chance to give you their opening statements for this phase of the trial if they choose to do so. State, are you prepared to proceed?
Yes, Your Honor.
All right, you may proceed.
We'll waive our.
All right, defense.
Thank you, Your Honor. May it please the court, opposing counsel, ladies and gentlemen. Again, I want to thank you all very much. Obviously, at this point, it's clear that there are some things that we disagree about. That's okay. It's also clear that there are some things we do agree about. And I'm glad to be on that same page with you as we proceed forward. We're here to decide the appropriate punishment. And that's an extremely difficult decision. That might be the most difficult part of any homicide case. The state is going to tell you about Mr. McIntyre's past criminal history and about things that were going on while this case that you all have heard was developing. You're going to hear about Mr. McIntyre's pending case for a murder charge in Fort Worth, where he was found guilty and he was punished for it as an accessory to the crime, as a party, not as the man who pulled the trigger, not as someone who was the direct and proximate cause of someone else's death, but as a participant in that criminal activity, much like you were charged on the law of parties in this case. You're going to hear evidence that Mr. McIntyre was on bond for that case when that happened. You're also going to hear evidence that Tamor McIntyre was 16 years old when this happened. He was a child. You're going to hear evidence that Tamor's childhood up to that point was far from idyllic. He was in the foster system with his sister. He was brought back to live with his father, who was extremely physically abusive to him, breaking bones, breaking ribs. He had to run away and go live with his sister in Corpus. You're going to hear about how that affects him and how it impacts his judgments. And we need to always remember as we go through the evidence in this portion of the trial that we are looking at this whole circumstance through the eyes of a 16-year-old boy who has had a traumatic and horrible life and whose judgment was impaired. You heard testimony in the guilt innocence phase about the fact that Mr. McIntyre had consumed LSD the night before. And while a lot of time had passed before the incident that you all considered in guilt innocence took place, we have to acknowledge that there are impacts on his perception of this situation. Now, we talked in jury selection. Intoxication is not an excuse. Intoxication is not a reason why someone should not be held criminally responsible. But it is absolutely something that you all should be considering when you're deciding what is the appropriate punishment. The punishment range for first-degree murder in Texas is anywhere from 5 to 99 years or life in prison. And that's a huge range of time. And we understand, I think, that not all murders are created equal. While we go through this, I ask that you all have some patience with me and bear with me. Because while I know that we all agree on one central thing, which is that there was not enough evidence to convict Mr. McIntyre of capital murder, there was not enough evidence that Mr. McIntyre robbed anyone, we certainly have differences of opinion about different aspects of this case, which I'm going to do my very best to respect. But I don't know exactly why each of you made the decision that you made in the guilt innocence phase. Some of you may have made it for different reasons. You only need to be unanimous about the ultimate conclusion. So there are things that I'm going to talk about that you may think, well, that's him talking about self-defense. And I've already heard that, and I don't believe it's self-defense. And come on, like, stop talking about self-defense. But remember, just because someone isn't 100% in the right doesn't mean the other person isn't partially in the wrong. And we have to acknowledge that every human interaction is a two-sided coin, and that there are aspects about Mr. McIntyre's perception on the world, his understanding of what was going on, the events that led up to being in that car with Mark, that have bearing on how responsible he should truly be in the grand scheme of things. Those are things that I ask you all to still consider, even though I gather you all have rejected the idea that what was done was justifiable by self-defense or otherwise. Keep those things in mind. Also keep in consideration things that relate to how Joanna behaved in all of this. While I understand that you all found Joanna credible enough to accept her testimony for the purposes of overcoming the accomplice witness rule, and I can understand y'all's reasoning there, please also understand that there are significant reasons why we should be suspect of Ms. Reyes's testimony. And those reasons have additional bearing into how you should make the decision to punish. Remember, Mr. McIntyre was 16 years old when this happened, but Ms. Reyes was 19 years old. Jeremiah was 19 years old. Mark was older than him. Jalen was the closest in age, but still older than him. Tamor is the youngest person in that car. And Tamor is now here in front of you, asking you all to decide how to punish him for this horrible, tragic thing. And keeping that aspect in mind, the motives of the other people, why things were done the way they were, all should be brought to bear, right? The fact that his presumption of innocence has ended does not mean that you all cannot continue to give some credence to the fact that Mr. McIntyre is, like all of you, a human being, and he deserves to have dignity in the way that his punishment is considered. And I want you all to think about some things that are surrounding the circumstances of this case. Because what we're here to talk about is not going to bring Mark back. It is not going to right any of the wrongs that you all have passed judgment about guilt and innocence on. Those things are not fixable. No matter what we were to do, we can't take back time. We can't take back these decisions. We are all having to move forward. And I would submit to you that the criminal justice system and the way that we handle the carceral punishment of people, locking people away, is just one idea out of many in how we address these otherwise unsolvable problems. It is good for the human heart. It's cathartic to try and see that someone is being punished for what they've done. And I understand that. And there's nothing wrong with that desire that we all feel, we all experience when we have identified that someone has done something that offends the values of society and that puts us in danger. And I respect that. But we have to also understand that it doesn't do any good to solve one wrong by committing another. And I would submit to you that because you will be asked to consider a wide range of punishment, And I would expect that what will be sought from the state of Texas on your behalf as the punishment will be an exceedingly long term of years to remember that there might be other ways to address problems in society than warehousing human beings. James Joyce, the Irish author, once famously said that Ireland was like a sow that ate her own piglets. And I worry sometimes that in America, that's what we have. We have children who are trapped in the foster system, children who are the victims of abusive parents, of parents with substance abuse problems, children who don't have any chance of having a proper moral compass, a proper guiding system. They have to figure those things out for their own. And unfortunately, they have to do that by trying to live in an adult world as a child. That's a pretty impossible ask. And yet we do it. And we arrest them. We certify them as adults. And we take them to trial. And we send them to prison for the rest of their life. And the world just keeps on turning. And folks, I just don't see that as being a sustainable model. It doesn't make anything better. It doesn't make anyone better. A little kindness, a little compassion, even in the face of something that we can all agree is evil, wrong, not acceptable, is always the better road to take. At the end of this, you'll all be asked to make that decision. We can't walk it for you. It's going to be personal to each and every one of you. All we ask is that you hear the evidence, that you understand we're not trying to paint this boy as a saint, and I'm not asking you to forgive him for what he did. I'm just asking you to keep it all in perspective and understand that while it's easy to say, you did something evil, we're going to throw you away, that as the prosecutor said in her closing argument, that if Tamor treated this boy as a piece of trash, then the implication should be that you should treat him as a piece of trash, isn't always the answer. Yes, the Bible talks about eye for an eye, but that's the Old Testament. And there is good news, and it's to turn the other cheek. I'd ask you all to keep these things in your mind as you hear the evidence. I thank you all for your deliberation and your patience with us up to this point.
All right, state, call your first witness.
Yes, Your Honor, the state calls Mia Valdez.
All right, if you can raise your right hand. Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, sir.
All right, you can lower your hand. If you state your name for the record and spell your last name, please.
Mia Valdez, last name Valdez.
All right, state your name, proceed.
Thank you, Your Honor. Ms. Valdez, can you please tell the jury what's your occupation?
I'm a fingerprint examiner for the Bexar County Sheriff's Office
And how long have you been an examiner there?
for 2 years.
And did you go through a certain training to become an examiner?
Yes, sir. I went through a 2-week course for identifying and classifying fingerprints as well as on-the-job training.
And have you testified here in Bexar County before?
Yes, sir.
And why don't you describe to the jury just what a fingerprint is?
Fingerprint is an impression consisting of characteristics that help identify an individual.
And what about an inked print?
Inkprint is the same thing, is used with ink pad and an inkprint card used for impressions of characteristics to identify an individual.
And so on these ink prints, are you able to compare ink prints with other ink prints?
Yes, sir.
And can you please describe to the jury how that is done?
Usually we use 12 set of characteristics to identify an individual using multiple methods, and then we're able to point out ridges and stuff like that for the identification.
And are you able to compare, well, one, are there unique characteristics to every fingerprint?
Yes, sir.
And are any two fingerprints, have you come across or known about any two fingerprints being the same?
No, not in my experience.
And I'm going to show you what's marked state exhibit number P1. Can you please tell me, tell the jury, one, can you identify that?
Yes, this is an ink print card.
And can you describe to them what print card?
Ink print card.
Ink print card. Can you describe to the jury what that is?
It is a card that has the impressions of the fingerprint using an ink pad.
And do you recognize this particular ink print card?
Yes, sir.
And how do you recognize it to be?
I was the one who was taking these fingerprints.
And the individual that you took those ink prints from, is that individual in the courtroom?
Yes, sir.
Can you please just point him out and identify an article of clothing he's wearing?
It's the gentleman in the gray sweater.
Now, did you have an opportunity to compare an ink print to another print on a judgment?
Yes, sir.
I'm going to show you what's been marked. State exhibit number P2. Can you tell me if you recognize that document?
Yes, sir.
And tell me how you recognize that document.
This was the judgment that I reviewed.
And is there a print in that packet?
Yes, sir.
And were you able to compare that print with the known ink prints that you took in the courtroom today from Mr. McIntyre?
Yes, sir.
And did you come to the determination if those ink prints match on those documents?
Yes, sir. They were a match.
And do you remember which fingerprint that was?
This one was going to be the right thumbprint.
And on that one, the state would offer state exhibit number P2 into evidence, Your Honor. At this time, we'll tender to defense for any objections.
No new objection.
All right, then states exhibits P1 and P2 are admitted.
Thank you. Now, particularly on state exhibit number P2, the named individual as the defendant on this, who is that?
That would be McIntyre Tamor.
And then also under the actual charge, what was the charge and the offense?
This was going to be for murder.
And what was the offense date?
Of offense date of 7/26/2016.
So July 26, 2016?
Correct.
Thank you. And then also on here, what is the plea to the offense?
Not guilty.
And then what is the verdict of the jury?
Guilty.
And was there a time assessed?
Yes, sir.
And what was that?
55 years, I'm sorry.
55 years?
Correct.
Onward to, that was under, is that a count 1?
Correct.
And then under count 2, is that also an offense named in that?
Correct.
And what is that offense?
Aggravated robbery with a deadly weapon.
And deadly weapon to it what?
To a firearm.
And what was the plea by the defendant?
Not guilty.
And what was the verdict of the jury?
This one was guilty.
And what was the punishment assessed?
This one is for 30 years.
Under count 3, what was the offense the defendant was convicted of?
Aggravated robbery with a deadly weapon, to wit, a firearm.
And in this particular case, what was the plea?
Guilty.
And then what was the years assessed?
13 years.
Under count 4, what was the offense which the defendant was convicted?
Aggravated robbery with a deadly weapon, to wit, a firearm.
And what was the plea to that offense?
Guilty.
And what was the punishment assessed?
13 years.
I'm going to show you what's marked P4. Can Can you look over that and tell me if you recognize that?
Yes, sir.
And looking at this document, is there any identifying numbers on there?
Yes, sir.
And also a name
Correct.
and also a date of birth?
Correct.
And does the SID identifier match the SID identifier on the judgment?
That is correct.
And do you know this to be a booking photo?
Correct.
You, Judge, at this time, the state would, I'm sorry. What is the identifying number of SID?
It's going to be the state ID number.
Can you call that out, please?
It's going to be TX 164-60189.
And on state exhibit number P4, does that match that SID number on that document?
That is correct.
At this time, Your Honor, the state will move into evidence P4. We'll send it to the defense for any objections.
No new objections.
All right, state's exhibit P4 is admitted.
Thank you, Judge. May I just call this to the jury?
Yes.
And this is what was identified as P4, and those are booking photos of this individual when he was booked in Tarrant County.
Correct.
Thank you. And again, he was convicted of 1 murder and 3 ag robberies.
Correct.
Thank you. We'll pass the witness.
All right. Defense, you may proceed.
Thank you, Doctor. 1 and 2 right there. Good afternoon, ma'am.
Yeah.
Do you have your microphone, Mr.
So
Turner?
sorry, I walked off without it. Does that work okay? I'm going to show you what has been admitted as States 2. This was the document that Mr. Gareham was just going over with you, right?
Correct.
And you indicated that it's Tamor Trayvon McIntyre,
Correct.
and it's out of Tarrant County, correct?
Correct.
And here, I want to call your attention to this portion here. What does the judgment say right there?
The sentence shall run concurrently.
Thank you. Pass the witness.
No further questions for this witness.
All right, is this witness excused or subject for recall?
Excuse by the state, Your Honor.
Excuse by the defense.
All right. The rule has been revoked. You're not allowed to discuss your testimony with anyone during the pendency of the trial.
Yes, ma'am.
All right, if you'll leave the microphone behind. State, call your next witness.
State calls Anthony Rodriguez.
All right, if you can raise your right hand. Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth to help you God?
Yes, ma'am, I do.
All right, you can lower your hand. Make sure you put the microphone on, please. And if you could state your name and spell your last name for the jury.
My name is Anthony Rodriguez. I spelled ANTHONY-RODRIGUEZ.
All right, state, you may proceed.
Sergeant Rodriguez, how are you currently employed?
I'm an investigator with the Bexar County District Attorney's Office. I hold the rank of sergeant. I'm a criminal investigator.
And how long have you been with the Bexar County District Attorney's Office?
I'm just over 12 years. February was my anniversary date.
Okay. Before becoming employed with the Bexar County District Attorney's Office, where did you work?
I spent 12 years with the Bexar County Sheriff's Office prior to coming here to the DA's office.
Okay, and when you worked with the Bexar County Sheriff's Office, what was your title or assignment?
For 10 years, I was the gang intelligence officer for Bexar County.
Okay, and did you specifically undergo any training regarding recognition of criminal street gangs?
Your Honor, can we approach?
Yes. I'm going to have you all step outside. I need to take up a matter outside your presence, and we'll bring you back in. You're not allowed to start deliberating or do any investigative work. Don't deliberate with each other or internally with yourself. I'll let you know when you're allowed to deliberate again. Everyone, please rise for the jurors. And my understanding is the witness is going to testify to potential gang affiliation or something of that nature.
That's correct, Your Honor.
All right, so I'm going to let the state ask their questions so I can see where this is going, and then I can hear objections and see whether there's a need for a hearing on expertise.
Thank you, Judge.
All right, you may proceed.
Sergeant Rodriguez, you said that during the Bexar County Sheriff's Office, you spent 10 years doing what?
I was the gang intelligence officer at the Bexar County Sheriff's Office.
Okay, and regarding any training and experience that you have, can you just briefly go over that to the board?
Yes, I'm a member of the Texas Gang Investigators Association, also the International Latino Gang Investigators Association. I have received training through the Texas Commission.
You all have dimmed the lights. Thank you. All right, I'm going to continue.
You have additional training through where?
Through the Texas Commission on Law Enforcement Standards and Education, otherwise known as TCO. But the primary form of my training was on-the-job training, interviewing gang members over those 10-year period, learning about the gangs from the gang members themselves.
Okay, and so I guess while you were employed with the Bexar County Sheriff's Office, did you spend some time in classification?
Yes, ma'am. So my primary job location was at the classification section. My primary duties were to house inmates, gang members specifically.
Okay, and so as a part of being a classification deputy, did you routinely conduct interviews with documented gang members?
And undocumented, yes, ma'am.
Okay, and do you have any other additional training regarding the recognition of criminal street gangs?
Outside of what I just mentioned, no, ma'am.
Okay, and as part of your current employment, do you keep updated with any literature or training materials regarding gang identification?
Yes, ma'am. So I am still an active member with the Texas Gang Investigators Association. I am also a liaison to the Texas Anti-Gang Center. I administer all the gang documentation here in the Bexar County DA's office. And I routinely consult for the office as a gang expert.
Okay. Now regarding how you're able to identify defendants as members of criminal street gangs, can you kind of just go over the different ways you'd be able to identify someone as a member of a criminal street gang?
Yes, ma'am. So Texas has a central gang database that's legislative. It's required by the law. We refer to that database as TexGang. That database requires all law enforcement agencies that are in a jurisdiction over a certain population to report all gang data to that central database. TexGang is what I check to see if this individual has ever been identified as a gang member. Outside of that, check to see if he ever been incarcerated in any other jurisdictions or agencies. Therefore, I can check to make sure if they've ever documented him. It may or may not have been a TexGang. TexGang has a lot of rules. One of the rules is that after so many years, it'll drop off the system. So if an individual has been documented, 5 years have passed, it could get dropped off.
Okay. But just regarding incarceration specifically, are you able to reach out to other, county jails or incarceration facilities and obtain documents that are kept in the regular course of business for them when they are classifying and housing defendants in their jail?
Yes, ma'am, I can.
Okay, and did you do that in this case?
Yes, I did.
Okay, and did you review the materials that were sent back regarding this defendant?
Yes, ma'am, I did.
Okay, and then did you form an opinion as to, well, if I could just, Judge, do you want me to just go over everything or just the qualifications for?
The qualifications and then how that is attached to the defendant, if something is attached to the defendant.
Okay,
Any underlying facts and data we'd like this month. The witness relied on in agreement.
well, they've been filed under the business records affidavit. I can give you a copy if you want.
I think we have a right to have the witness proffered to the court for the review.
All right, so this is what the court is going to say. I just want to know from this witness, his level of expertise, how is it related to this specific case and this defendant? And then you can pass for this.
All right. Now, regarding the defendant, Timur McIntyre, did you gain knowledge that he was incarcerated in the Tarrant County Jail previously to being incarcerated in the Bear County Jail?
Yes, I did.
Okay, and did you reach out to Tarrant County and obtain records regarding his classification in the Tarrant County Jail? Did you obtain those records that were regularly kept in the course of business there?
Objection, this isn't the witness who could attest to what's regularly kept in the course of business in Tarrant County.
All right, that objection is overruled.
Did you obtain a document from Tarrant County?
Yes, ma'am, I did.
And did they come with a business records affidavit?
Yes, ma'am, they did.
And you reviewed that?
Yes, ma'am, I did.
Okay, thank you. And after reviewing those records, were you able to form an opinion as to whether the defendant was ever affiliated with a criminal street gang?
Yes, ma'am, I did.
Okay, and what gang was that?
He's a member of a Crip gang, otherwise known as the Long Beach Insane Crips.
Okay, and was that determined through a self-identification or what means?
It was determined from a self-identification gang acknowledgement form obtained by Tarrant County.
Okay, and can you just explain to the court what that form is?
So this is a correctional form. It's used in jails and detention. It's used primarily to house individuals. So when somebody comes into a facility, they are approached by what we call a classification officer. This is an individual that houses people in the jail. They're asked a series of questions. One of those questions is going to be, are you a gang member? Many individuals will admit gang affiliation at this time, so they are housed appropriately. They don't want to be housed with rival gangs or things of that nature.
Okay. And do you have knowledge about the Crips Criminal Street Gang?
Yes, ma'am.
Okay. And based on your knowledge of that gang, do you have an opinion as to the purpose of that gang?
It is a criminal organization. It's a group of individuals that are together for the purpose of committing criminal activities.
Okay, and in your training and experience, what type of criminal activities would there be?
They range everything from narcotics all the way up to murder.
So we have the witness.
All right.
Thank you, Judge. Good afternoon, sir. How are you?
Excellent, sir. Yourself?
I'm doing all right. You indicated that you checked databases to see whether or not Mr. McIntyre was listed as being affiliated with the gang, right?
Yes, sir, I did.
And you mentioned Tex Gang is a statutorily required, statewide database about gang affiliation in prisons.
Yeah, no, not in prisons, jails. Well, by law enforcement, not exclusive to just jail.
Okay, just so it could be people on the streets, people in jails, people in prisons.
Not prisons, everything but prisons. I checked a separate database for that.
Okay. Are you aware that many gangs have different organizational structures for people who are incarcerated versus people who are out on the street?
I'm going
Yep.
to object this. Well,
How is that
outside of the scope of
relevant?
this hearing.
It goes directly to his qualifications.
All right, so I will hear objections and rulings on them. All right, you can answer the question.
Can you repeat the question, sir?
You're aware that oftentimes when we talk about a criminal gang, that gang may have people on the outside and it may have people on the inside. They often have different organizational structures, right?
That's possible, yes, sir.
Okay. And was it, just so we're clear, was it Tex Gang that you consulted that actually said Tamar McIntyre is a member of this particular gang?
Yes.
Okay, so it wasn't an independent document from Tarrant County, or it was a document from Tarrant County in Tex Gang? Can you just explain
Sure.
your method of determining this a little bit more clearly?
Sure. Text gang has a 5-year requirement, meaning that if you're in the system for 5 years and you're not validated, meaning that another law enforcement agency hasn't added to text gang, you are dropped off the system. So McIntyre was in text gang from a earlier admission. He had since dropped off text gang. However, text gang still showed that at one point an entry was made. So to answer your question, I had to do both. The first thing was I acknowledged that there was an initial entry in text gang, but to validate that initial entry to ensure that it is in fact the defendant, I reached out to the county that entered that information, and that county is Tarrant County.
Okay, so to be clear, if we were to go look him up right now, Mr. McIntyre is not in text gang.
He had since dropped off text gang, yes, sir.
5 years ago.
After 5 years. So the original entry date, I believe, was 2017.
Okay, I see. Gotcha. So what? Three years ago.
Yes, sir.
Something like that.
Yes, sir.
Okay. You mentioned that Long Beach Insane Crips is a criminal enterprise, basically. Is that your testimony?
The Crips gang is a criminal organization, yes, sir.
Okay, when you say the Crips gang, you understand there are lots of different subsets of what you call Crips, right?
Yes, sir, there is.
And that many of them have no affiliation with each other whatsoever, right?
That's true, yes, sir.
In fact, some criminal elements that would call themselves Crips are actually fighting each other, right?
That's true.
So you can't say that it's just Crips, therefore it's a criminal enterprise, correct?
Are you talking about this particular gang or all gangs?
I'll withdraw that question. Let me ask you more specific. Have you ever investigated, other than Mr. McIntyre, any other individual person who's a member of the Long Beach Insane Crips?
No, sir, I have not.
Have you ever encountered anyone who is a former gang member from the Long Beach Insane Crips?
No, sir, I have not.
Do you know anything about the organizational structure of that entity, the Long Beach Insane Crips?
I have some knowledge of it, yes, sir.
Okay, well, when you say you have some knowledge of it, is it based upon your own investigative work?
Yes, sir.
Okay, but you indicated you never investigated anybody associated with that gang, so help me understand.
I never investigated a person associated with that gang, but I have looked into the gang.
Okay, when you say you've looked into the gang, are you talking about Google or are you talking about something more?
So, sure. So we get reading material that's nationwide, primarily from the International Latino Gang Investigator Association, also from the Regional Organized Crime Investigation Center, that provides reading material from various law enforcement agencies throughout the country. This particular gang, the one you're asking about, sir, is a California-based Southern gang. So when I learned of this particular group, I went to that reading material from the southern part of California. There I was able to learn a little bit more about this gang.
Okay, well, I mean, so for example, you my guess is you have more dealings with some of the Latino gangs here in San Antonio, right? There are quite a few of them in the jails.
Yes, sir, there are.
Okay, so for example, you know that what is going on in Los Angeles with a gang like the Latin Kings isn't necessarily reflective of what anyone who calls themselves that in San Antonio is doing. You understand that happens a lot, right?
I mean, it's kind of a broad question there, sir. There could be some takeaways from incidents in one state that carries over to incidents in this state.
But oftentimes there's no similarity, right? There are plenty of gangs who don't do the same things or have the same structure in one state versus another. Do you agree?
I cannot agree with that, sir, no.
Okay, you think that all people who affiliate with a gang in every single state where they might be locked up all working under a common objective?
That's why it's called an organized criminal gang, sir. They have an organized structure. They have rank. They have written constitution and manifestos that allows them to remain a structured, organized group, regardless of the state or the location.
Do you have the manifesto of the Long Beach Insane Crips?
I do not, sir.
Do you have any idea who's the leader of the Long Beach Insane Group?
No, sir, I do not.
Do you know who's the sergeant at arms for that organization?
No, sir, I do not.
Do you know if they even have a sergeant at arms?
I'm sure they do, sir.
I'm sure they do, but do you know if that's what he's called?
No, sir.
Okay, so you don't know anything about the structure of the gang, right?
I have some knowledge about it, sir.
Okay, you read a publication from someone in Southern California.
Yes, sir.
Who authored that publication?
I don't know, sir.
Okay. You understand that when people get classified, there are often reasons other than organized criminal activity why they might want to be associated with a particular group of people, right?
No, sir, I do not.
Okay, well, do you think that someone who's African American going into a jail would say, I'd like to join the Aryan Brotherhood, mark me down as an AB?
Objection, relevant.
Sustained.
Well, I mean, you understand that there are racial reasons why people join particular groups in jails, right?
Objection, relevant, and outside the scope.
Your Honor, he testified
This
that,
is outside the scope of the expertise. I think my understanding from both parties that the purpose for questioning this witness is to determine whether or not he's an expert in whatever field he's being presented, which appears to the court that he's being presented as an expertise on gang affiliation or gang classification. And then the other question the court wanted to know was, how would that be relevant to this case, whether or not it's tied to your client or not? So if we could remain within the bounds of this actual hearing.
Your Honor, I think that pretty well establishes what my objection should be. I'm ready for argument.
All right, the court will hear argument.
Your Honor, the witness is not sufficiently familiar with this organization to be able to give an opinion about whether or not it truly is a criminal enterprise and whether or not Mr. McIntyre is even still a member of it. He has a notation from a database that is no longer considered active by the database, that when he was first booked into Tarrant County or at some point in the past while in Tarrant County, he was affiliated with this organization. We're backdooring hearsay. I have no ability to confront the individuals who screened him, or as to how he was screened, or whether he even got to participate in the screening process, or whether it was done for him. The witness has no personal experience with anyone affiliated with the organization. He's basing this off of what's basically a trade publication from someone in law enforcement in Southern California, without any understanding about how that relates to San Antonio or Texas generally. And I think that under those circumstances, he's not qualified to testify about this organization for any purpose. It would backdoor in hearsay that violates the confrontation clause, and its prejudicial effect is through the roof. And there's not even any indication that Mr. McIntyre is still involved with this.
All right, so this is what the court's question is. One, gang affiliation is allowed as relevant information during punishment. The court is finding that this is relevant, but the next question the court wants some clarification on is, when is this alleged affiliation to have occurred?
And so I have the exhibit offered to this witness, but it was when the defendant was incarcerated in Tarrant County back in 2017, and I mean, he hasn't been out on the street since, so I think it's relevant. It goes to evaluating the defendant's background and character, which defense has put on issue in his opening statement when he was proffering that the jury was going to hear that the defendant had such a rough upbringing. And this witness is an expert. He has a lot of knowledge dealing with gang members and specifically the Crips. I think Mr. Hunter essentially stipulated that this is a subset of the Crips criminal street gangs, and this witness is familiar with that criminal street gangs violent and illegal activities, which he's testified to, and he is able to form an opinion based on the materials that he's reviewed as to the defendant's membership in the organization.
I'm not stipulating to anything. This all is conduct that occurred after the offense date in this case, while he was incarcerated. And the witness is, I don't believe, qualified to tell the jury anything about this organization, much less whether it's affiliated with any criminal entity that calls itself Crips, or what its purpose is, or who its membership are, or whether Mr. McIntyre is a member. And so while I would agree with Your Honor that if we had evidence that Mr. McIntyre did this as a gangland shooting, it was for the purpose of advancing a criminal enterprise, it would absolutely be relevant. There is no relevance to the fact that he was booked into Tarrant County and someone says that back then he identified as being part of this organization. I think that is not relevant. And all it does is to make people believe impermissibly that because of decisions that he made in jail, which we can't really even say are criminal or underhanded, that somehow should have bearing upon how he's punished for this offense that occurred before he was even documented to be part of any offense.
So it's not required by law for it to be relevant as character evidence that the offense that we're here for is tied to his gang admission. And it's not somebody just saying this. The defendant said it back when he was in Tarrant County. And so it's a statement against interest, a statement against party opponent. And I mean, this evidence has been filed with the court since December of 2024. So his objections to hearsay and stuff, I mean, there's an affidavit that is going to authenticate this information.
It more to the point is a Crawford, it is a confrontation issue because it's a double hearsay problem. They're offering the statement as an admission by party opponent, all right, fine. But what's being discussed here is not the actual admission by the party opponent. What's being discussed here is the entry by a data clerk that he should be classified as a member of a gang that is in the text gang database because of something he said at booking. We don't have the statement exactly that was said at booking. We've got a summary of that. So I think that that's the reason why there's a confrontation problem, irrespective of whether it would come in as an exception to hearsay or a non-hearsay statement. But more to the point, I mean, she said a moment ago that it's somehow connected to the offense. There's been no evidence in guilt and innocence that it's connected to the offense.
Or does it have to be connected to the offense?
Well, I mean, I think she
And I
argued
didn't
it
say, I
was.
did not say that. I said it is not required by law to be relevant in punishment to come in. That's not required, that I prove that he was acting under color of his gang when he committed this.
I know you said that too, but did you not also argue that
All right,
it's connected to the offense?
I did not say that.
Is going to rule. The court is going to allow the witness to testify. Is there anything else?
No, Judge.
All right, does anyone need a break before I allow the jury to come back in?
I would like to rather.
All right. So if I could have you all back here, 3:50?
350.
Yes.
Thank you, Judge.
Okay, I'm in there cooking. Let me advance this.
Yes.
All right, for the jury.
All right, everyone, please be seated. All right, stage, you may proceed.
Thank you, Judge. All right, Sergeant Rodriguez, so I think we left off on your training and experience. So You're employed with the Bexar County District Attorney's Office, is that correct?
Yes, ma'am, I am.
And how long have you been doing that?
I've been with the Bexar County District Attorney's Office for a little over 12 years now.
And what are your duties with the Bexar County District Attorney's Office?
I'm a criminal investigator. My primary duty is to assist the prosecution with trial preparation.
Okay. Do you have any ancillary duties in your employment?
Yes, so I'm also the gang investigator here. I have a liaison with the Texas Anti-Gang Unit. My secondary job is to ensure that all of our investigators have access to research gang membership and to consult with all the prosecutors here to identify if either the defendant or a witness or a suspect is gang affiliated. I provide expert opinions on their gang membership and occasionally, like today, testimony.
All right. And before you became employed with the District Attorney's Office, where did you work?
I spent 12 years with the Bexar County Sheriff's Office before I came to the District Attorney's Office.
Okay, and during your time with the Sheriff's Office, what were your duties?
Started my career as a jailer. I was a jailer for 2 years, and then I spent the next 10 years as the gang intelligence officer at Bexar County Sheriff's Office. My job was with the classification section. It's a section that is responsible for housing inmates. The primary inmates I was responsible for housing were gang members.
All right. And as your duties as a classification officer, what did that routinely entail?
It routinely entailed interviewing individuals that were either suspected or self-admitted members of a gang. And so my job was to talk to them and to ensure that they were in fact an actual member so I can appropriately house them.
Okay. And so it was routine in classification that these interviews would be conducted to appropriately house the defendant, is that correct?
Yes, ma'am.
Okay. Now, do you have any other specialized training regarding the recognition of criminal street gangs?
So I'm a member of the Texas Gang Investigators Association. I've been a member since my time at the Sheriff's Office. I'm also a member of the International Latino Gang Investigators Association. I've received training through both of these associations on the subject of gangs. I've also received training through the Texas Commission on Law Enforcement Training and Standards. This is what we call TCOLD. I've also received some standalone training during the course of my career, but my primary training came from the gang members themselves. Every time I would interview these individuals, they would teach me really, how to recognize their affiliation with the gang, where it was.
Relevance here, say.
All right, that will be sustained.
Motion to instruct the jury to disregard.
All right, ladies and gentlemen, you'll disregard the last statement
Motion to mistrial.
tonight.
All right. Now, have you, or were you, I guess, in your analysis of whether a defendant is associated or a member of a criminal street gang, can you kind of explain to the jury how you would obtain that information?
The primary thing that we do is we simply ask the individual, are you a member? Being that it's a correctional setting, many individuals will self-admit gang affiliation, so they are housed with their own people. We don't put them with a rival gang. Outside of the self-admission, outside of us just asking, there's a number of things that we look at to identify gang affiliation. Gang members are experts in nonverbal communication. We've all seen it, whether it be a tattoo, clothing, gang hand signs. So we have training and expertise in identifying those nonverbal cues to identify gang affiliation. Secondly is the intelligence, whether it be from jail calls or jail mail or other individuals. Finally, we look at the cases. What are they charged with? Who are they charged with? Where do these crimes occur? Are these crimes occurring in neighborhoods that are notorious for a particular gang or gang set?
Your Honor, may I approach the witness?
Yes.
All right, I'm going to show you what's been marked as State's Exhibit P3. Can you take a look at that and tell me if you recognize that?
Yes, ma'am, I do.
Okay, and have you seen State's Exhibit P3 before?
Yes, ma'am, I have.
Okay, and can you explain to the jury what P3 is?
P3 is a gang acknowledgement form. So in a correctional setting, when you identify somebody as a gang member, we want to make sure we capture that information. We capture it by documenting it in a gang form. What I have here in P3 is a gang form.
Okay, and just regarding State's Exhibit P3, I know earlier you spoke when a defendant is classified in the jail, there's documentation. And so did you reach out to the Tarrant County Jail and personally obtain State's Exhibit P3?
Yes, ma'am, I did.
All right. I'm tendering to defendants for inspection, but at this time, the state offers State's Exhibit P3 under Rule 803.
Your Honor, can I void our witness about something?
Yes.
Officer, in reviewing P3, there are photographs of Mr. McIntyre without a shirt on, correct?
Yes, sir, there are.
And they document some tattoos that Mr. McIntyre has?
Yes, sir, they do.
You're not testifying that any of those tattoos are affiliated with any criminal organization or marker of those organizations, are you?
I am not, sir.
Okay. Then no new objection.
All right, State's Exhibit P3 is admitted.
Permission to publish, Your Honor.
Granted.
Okay, Sergeant Rodriguez, and so have you had a chance to review the contents of State's Exhibit P3?
Yes, ma'am, I have.
And have you formed an opinion as to the defendant, Tamor McIntyre's involvement in a criminal street gang?
Yes, ma'am.
And what is that opinion?
Objection, opinion on observation.
On the roll.
You can answer.
He is a member of the Long Beach Insane Crips.
All right. Now I'm publishing State's Exhibit P3. Can you explain to the jury what this first page is?
When you receive a documents and you want to have them admissible in court, we
Objection,
reject.
Your Honor, relevance calls for a legal conclusion.
All right, that believes the same.
Motion to instruct the jury to disregard.
All right, ladies and gentlemen, you should disregard the last question.
All right, Sergeant Rodriguez, regarding this first page, is this something that you received when you requested the evidence from Tarrant County?
Yes, ma'am, it is.
All right. Now regarding this page, I guess, can you see it up there?
Yes, ma'am, I can.
All right. Can you explain to the jury what this page is?
This is the document used by law enforcement to capture and collect information acknowledging gang affiliation.
All right. And just regarding the name of the person, can you tell the jury what that name is?
Yes, ma'am, it's,
Sorry, Your Honor, just for, make sure the record's clear, if I could have a running objection as to the explanations about the content of the document as to my hearsay confrontation and 702 objections. I just want to make sure I'm not objecting all through her examination.
All right, you may continue.
Thank you. All right. Can you please tell the jury what that name associated with this gang update sheet is?
yes, the name is Tamor McIntyre.
And what is the CID?
That is the correctional identifying number. That is a number used by this corrections agency. It's a unique number specifically attached to Tamar McIntyre.
All right. And regarding the date of birth associated with the defendant?
June 16th, 2000.
And sorry, just to back up, what is the CID associated with this defendant?
That is the specific and unique number given to the defendant by the agency.
And what is that in this case?
What is the agency or the number?
The number.
The number is 0905728.
All right. And can you explain to the jury what the affiliation, moniker, and ranking is?
The affiliation is the name of the gang. So in this case, Tamar has identified himself as a Long Beach Insane Crip gang member. The moniker is the nickname that he uses as a member of that gang. In this case, it's TK47, and he's identified himself as a member of that gang.
All right. Regarding the affiliation or ranking determined by, can you explain that to the jury?
Yes, ma'am. So this, what they're identifying here on the form is how they identified him. In this case, number 3 is selected, indicating that Tamar has identified himself as a member. Number 6 has been selected. There are a number of options under number 6, ranging from gang dress, hand signs, tattoos, or symbols. In this particular case, he provided intelligence on hand signs that are unique to this particular gang. And finally, number 8, which is use of technology or the internet for recruitment.
I'm going to object. First Amendment, right of free association, right of free expression.
All right, that'll be overruled.
Thank you. Now, regarding this area, I guess, can you explain to the jury what you reviewed regarding the specific comment section?
These are the notes that are documented by the agency. In this particular case, it is indicating that he self-admitted membership on July 26, 2017 with the Eastside Long Beach Insane Crips. It also indicates that photos were taken of the defendant and social media photos were collected during the course of their investigation.
Now, regarding what's depicted on the screen, can you just explain to the jury what they're seeing?
These are images that they collected during the course of their investigation into his social media profiles. As it's identified in the gang letter, the defendant explained what these hand signs mean in these images.
And I guess hand signals, are those something that are synonymous with different gangs?
Yes, ma'am, they are.
And each gang has their own hand signals, is that correct?
Yeah.
Sister. Regarding gangs, do all gangs have the same hand signals?
No, ma'am, they do not.
Okay, and so I guess regarding this hand signal, what was it self-identified as?
This particular hand signal identifies the gang, the Eastside Long Beach Insane Crip. This is a specific hand sign that identifies the gang.
And regarding this hand signal, what was that self-identified as?
Bloods and Crips are part of a larger universe. They're part of nations, people, and folk nation. In this particular case, he's throwing a hand sign that represents the folk nation. It's just a larger group within the group that he's representing.
And then this hand signal, what was that self-identified as?
This particular hand signal, he's identifying a status within the gang, a rugrat. This is could mean a prospective member or somebody who's entering the gang.
And I guess, can you just explain to the jury what this form is that they're seeing?
At the time of housing, classification officers will ask a series of questions. These are stability factor questions. These enable the classification officer to appropriately house. These questions are generally outside the gang affiliation. These are more about the individual themselves.
And then just regarding this line right here, can you explain to the jury what that is?
Yes, it's a little redundant, but it's once again, they asked the defendant if he's a member of a gang, to which he replied that he's a member of the Crips and gave his alias or nickname.
Now, regarding the photos that we just saw with the hand signals, what did you personally see when you observed those photos?
Outside the hand sign, once again, gang members are notorious for nonverbal communication. The Long Beach Insane Crip generally wear black or gray. And in almost all of those images, he's wearing a black shirt, which is another indicator of gang membership.
Okay. And are you familiar with the criminal street gang of the Crips?
Yes, ma'am, I am.
Okay. And based on your knowledge of that gang, do you have an opinion as to the purpose of the gang?
Objection, relevant.
Relevance. Well, Judge, I mean, it goes to the reputation and character of the defendant.
It's a different gang than what he just testified to.
Well, I'll re-ask the question.
All right, so that objection will be sustained.
Motion to instruct the jury to disregard the question.
All right, ladies and gentlemen, you're to disregard that last question.
Motion for mistrial.
Denied.
All right, so as part of your employment with the Bexar County District Attorney's Office, do you keep updated with any literature that's coming up about any gangs?
Yes, ma'am, I do.
Okay. And so regarding this Long Beach Insane Crips gang, have you been able to form an opinion as to the purpose of the gang?
Yes, the gang is a criminal enterprise. That's a group that is designed or created for the sole purpose of engaging in criminal activity for the benefit of the gang.
And are you aware of any crimes specifically associated with this subset of the Crips?
With this particular one, no.
Okay. And regarding the overlying or Folk Nation Crips, what are the crimes associated with those gangs?
Yes, the Crips.
Objection, relevant.
Overruled.
You can answer.
The Crips are a criminal enterprise. They engage in crimes ranging from narcotics all the way up to murder.
And based upon what you've reviewed in State's Exhibit P3, have you formed an opinion as to whether the defendant was a member of the Insane Long Beach Crips?
Yes, ma'am.
Then what was that opinion?
He is a member of the gang.
We pass the witness, Your Honor.
Thank you, Your Honor. You said you're primarily employed with the Bexar County District Attorney's Office, right?
Yes, sir, I am.
And so you're obviously familiar with this case and Mr. McIntyre's reason for being in court, right?
Vaguely from what I've seen on, the news and whatever.
Okay, so you haven't reviewed any of the evidence in this case?
No, sir.
So you're not giving the jury an opinion that anything about the criminal offense that we're here to talk about was done in conjunction with a criminal street gang or for or because of a criminal street gang?
I don't have any of that knowledge. No, sir.
Okay. You testified a moment ago on what I just want to make clear. There are photographs of tattoos of Mr. McIntyre's in that packet that the jury has, right?
Yes, sir.
You're not saying any of those tattoos are affiliated with the Long Beach Insane Crips?
Yeah, I have no knowledge of that, sir.
Okay. As far as the hand gestures that you mentioned, you don't have any personal knowledge of seeing people throwing up those signs as being gang signs, do you?
No, I do have personal knowledge of seeing people throwing up gang signs.
And I guess what I mean by that is, have you ever seen a person in real life throwing up those specific gang signs to show allegiance and affiliation to the Long Beach Insane Crips?
For the Long Beach Insane Crips, no, sir, I have not.
Okay. You indicated that the reason why you have this material is because it was self-reported by Mr. McIntyre when he was booked into the Tarrant County Jail, correct?
Yes, sir.
And that would have been in July of 2017, is that correct?
I believe so. Yes, sir.
Okay, so after the date of offense in this case, right?
I don't know the offense date, sir.
Okay, April 23rd, 2017 would be before this information was reported, right?
Sure.
So we don't have any knowledge or any record that indicates he was an affiliate or member of this gang at the time of the offense, correct?
I'm unaware of it, sir.
Okay. You indicated that this is something that's done for all people who are being brought into the jail in Tarrant County, right?
I believe it happens in all the jails, sir.
It happens here, for example, too, correct?
Yes, sir.
You didn't provide any records of Bear County classification, right? Bear County just used what Tarrant County says.
And I didn't see anything from Bear County, so I would have to assume that yes, they use what Tarrant County
Well, we
sent.
don't want you to assume. So you have not seen anything from Bear County, right?
Correct.
Okay. And you were talking about the nature of criminal gangs. You'd agree with me, there are criminal gangs that operate out in the free world, and there are criminal gangs that operate solely within correctional institutions, be they jails or prisons.
Yes, sir.
And sometimes those organizations span both, and sometimes they don't, right?
Yes, sir.
You don't have any specific information about how the structure of the Long Beach Insane Crips operates, do you?
I have some knowledge about it, sir.
Well, I mean, as to whether it's primarily a jail gang, primarily a prison gang, primarily a gang that operates out in the free world, you don't know much about its structure, do you?
So for this particular gang, there are two parts of it. You have the street gang, which is a Long Beach, and you have the Crips, which is a prison gang.
Okay, well,
This group is both.
let me back up. The Crips is a term that encompasses hundreds, maybe thousands of different groups of people, right?
Yes, sir.
And you're not suggesting that all of those people know each other, talk to each other, get the newsletter, right?
I'm unaware of a newsletter, sir.
Okay, you're unaware of any other way in which there's mass communication between all of these people, correct?
No, I am aware. So it is an organized gang. They do have an organized structure and I'm talking about the Crips as a whole, not the individual subsects. And they do communicate. We are well aware of that.
Let me just ask you this. You're aware that some groups that would call themselves Crips are actively in gangland wars with other members of the Crips, right?
Yes, sir. That's true.
So just the fact that they're both Crips doesn't mean that they're unified together, right?
Depends which ones you're talking about, sir.
But there are certainly, not all of them are on the same page, fair to say?
Sure. Yes, sir.
Okay. And you're aware that there are lots of legitimate business things that individuals who identify as Crips engage in, right?
Yes, sir.
They own businesses, for example.
Oh, I'm unaware of that, sir.
Okay. You're aware that there are a lot of popular musicians and artists that identify as being members of some subsect of the Crips, right?
I've heard of that. Yes, sir.
And of the Bloods, right?
Yes, sir.
Okay. Now, the Crips and the Bloods have predominantly been African American gangs, right?
Yes, sir.
Relevance.
I think it's extremely relevant.
What's relevance?
We're talking about jail classification and reasons why someone might jail classify other than a desire to commit criminal activity.
All right. Objection is overruled.
So the Crips and the Bloods are predominantly African American gangs, right?
Yes, sir.
The Otojones and the Tango Blast and Latin Kings are predominantly Hispanic gangs, right?
Yes, sir.
The Aryan Brotherhood is a white supremacist gang.
Yes, sir.
Okay, so people that book into a jail, when you talked about wanting to be housed with their own people, part of that is about if they are a member of a gang, they don't want a rival gang to be where they live, right?
Correct.
But it's also to some degree about racial divide, is it not?
Depends on the gang.
I mean, an African American probably doesn't want to classify as an Aryan Brotherhood member, right?
I would think not.
Okay, and that's about their personal protection and safety in the jail.
Sure.
Okay. Were you asked to do a review of any other individuals in association with your work in this case?
No, sir.
Okay. So you would be unaware if any other individuals that were investigated in this case are members of any criminal street gang?
Correct.
Okay. And this information, to be clear, comes from a centralized database maintained by DPS, right?
Yes, sir.
And Mr. McIntyre's entry into that database had actually fallen off, you said, correct?
Yes, sir.
Meaning that he reported it so long ago that it's no longer in the database today, correct?
Correct.
Okay. You had to go back to Tarrant County to find their records to see that that was something he said when he was first classified.
Yes, sir.
Okay. And you don't know of any corroborative work that's done by the people in Tarrant County to confirm what Mr. McIntyre or anybody else says when they self-report affiliation, right?
I don't understand that question.
So, I mean, if someone walks in and they say, I'm a member of such and such criminal street gang, right? And somebody goes, okay, well, fill out this form, check the box, I'm going to put it in the system. You don't know of any efforts that are done to go and check that out, right? It's not like, well, or do you?
Well, he housed with other members in
Okay.
Tarrant County, and he seemed to be fine over there. So I think the members corroborated the information for us.
Okay, so you think just because no incidents occurred while he was locked up with those people, that corroborates it, right?
I mean, I would think so. Yes, sir.
Okay. If it's not like someone was out there, hitting the streets in the free world, interviewing people to confirm whether or not what a man says when he's booked into the jail is actually true as far as the free world is concerned.
I'm unaware of any of that, sir.
Jails are very difficult places to be living, right?
Objection, relevance.
Overruled.
A jail is a difficult place to live, wouldn't you agree?
I would think so. Yes, sir.
You're surrounded by people who are there because they've either been accused of or convicted of breaking the law.
Yes, sir. That's true.
And so people are sometimes violent in jails,
I believe so. Yes, sir.
and there's drug use in jails.
I'm sure there is.
There are people who are trying to blackmail other people in jails.
I would think so. Yes, sir.
Well, you worked at the sheriff's office too, correct?
Yes, sir.
So you're aware that the sheriff's office has extensive training of their jailers to how to avoid being blackmailed by people who are locked up in there, right?
Yes, sir.
So you know that those kinds of con games and attempts at compromising a person happen all the time in jails.
It does happen. Yes, sir.
There's people being sexually assaulted in jails,
Objection, relevance.
Overruled.
right?
I'm sure there is. Yes, sir.
Okay. And so there are only a finite number of jailers that can watch these people, right?
Yes, sir.
And there's recording equipment and surveillance equipment in jails, but it doesn't catch every single nook and cranny of the jail, right?
Correct.
And so people often have to look out for themselves when they're locked up. You'd agree?
Yes, sir.
And that requires not doing things that will upset other people who might not be the most reasonable and rational, right?
Sure. Yes, sir.
You don't want to pick fights with somebody who's, a 6'5", 5-time serial killer, right? That wouldn't be a good idea. You'd agree?
Yes, sir.
Okay. It means that if you are trying to avoid being taken advantage of and things like that, you need to try and make relationships with other people, other inmates.
Yes, sir.
You mentioned that the name of this group is the Long Beach Insane Crips, right?
Yes, sir.
And you mentioned that as it stands in the free world, their origin is in Long Beach, California.
Yes, sir. That's true.
Okay. And you know that as groups get more prominent in different facilities in different states, different jurisdictions, there may be differences in leadership or policy or attitude between those different facilities, right?
I'm sure that's true. Yes, sir.
Okay. And you don't know anything about the president of the Long Beach Insane Crips that would be running things in Texas,
No, sir, I do not.
or any of the other officers that might be involved in that structure,
No, I do not.
or even if that's how exactly they structure their organization.
With your exact terms that you're using right now?
Well, right. I mean, when we think of an organization, we think of it as having a hierarchy, right?
Yes, sir.
But not all groups have the same kind of a hierarchy.
In organized crime, which is what the Crips are, there is an organized structure. What this particular organized structure is,
You're going to object to non-responsive.
Call the roll. You can answer the question.
the Crips are an organized structure. They have an organization. I think you're asking me to use your words to identify that organized structure. What I'm telling you is, I don't know who the members are that meet those particular organized ranks, but they do have them.
Okay, well, what are the ranks?
Well, you have what's called an OG or an original gangster. This is somebody who's a founding member. And then you have a youth or a youth member. These could have different other names for them. And in between all that, you have soldiers, which are either incarcerated in prisons or out in the streets.
Okay, so you think that generally that's how all of these gangs operate?
No, sir.
Okay. You think that that's how the Crips operate?
Some Crips. Yes, sir.
Some Crips.
Correct.
As to the Long Beach Insane Crips, you don't have any specific information about members fulfilling these hierarchical roles?
No, sir, I do not.
Pass the
Sergeant Rodriguez, in Texas, is there such thing as an ex-gang member?
Yes, there is.
Okay. And if somebody was an ex-gang member, when they go to be classified, is that something that would be notated on the documentation?
Yes, ma'am, it would be.
Okay. And when we talk about corroboration and whether people in Tarrant County went to corroborate, I mean, the photos that you've seen, you'd agree with me, those were taken way before the defendant was ever in the Tarrant County jail, correct?
objection leading, Your Honor.
All right, with regards to leading up,
Motion to instruct the jury to disregard the question.
all right, ladies and gentlemen, disregard the question.
Motion for disregard.
Denied.
Have you had a chance to observe the photos that are contained in State's Exhibit Q3?
Yes, ma'am, I have.
Okay, and specifically these photos, were those taken when the defendant was inside of the Tarrant County jail?
No, ma'am, they were not.
Okay, and so, I mean, in your opinion, would these hand signals
No, no, no,
corroborate?
object to personal knowledge.
Which are you referring to? I'm sorry.
Objection is overruled. You ask your question.
Just a second.
Oh, I see. I withdraw the objection.
All right, now regarding this photo that's depicted on the overhead, is that photo taken in the Tarrant County jail?
No, ma'am, it's not.
All right, and so would the hand signals corroborate the defendant's self-admission in your opinion?
Yes, ma'am, they would.
You pass the witness now.
Briefly, Your Honor. You indicated that these documents and these photographs showed something about a gang sign about being a rug rat, right?
Yes, sir.
Which you indicated was someone who's a prospective member of the gang. Right?
Yes, sir.
Which you mean that they're not a member of the gang at the time. They're trying to get in.
Right, correct.
Okay. You are not aware of any specific crime perpetrated on behalf of the Long Beach Insane Crips, right?
Can you rephrase that?
You don't know of any specific crimes that have been committed for or by the Long Beach Insane Crips to promote or further its enterprise.
So are you asking if I have direct personal knowledge of a specific crime committed by that group, or am I aware of the gang's involvement in criminal activity?
The first question.
I am not aware of specific crimes committed by that gang.
That's the witness.
No further questions and excuse by state.
Excused.
All right, the rule has been invoked. You're not allowed to discuss your testimony, but therefore your dependency of this trial.
Thank you, Judge.
All right, state, call your next witness.
Stay rest, Your Honor.
Now we approach.
Yes.
All right, ladies and gentlemen, the state has rested for this phase of the trial. What I'm going to do is I'm going to give you all your recess for today, but I don't want you all to leave the jury room just yet. I'm going to speak to both the state and the defense to see what time they would like for you all to be back tomorrow, because I don't want you to come back into the morning just for me to tell you, no, it's going to be the afternoon. So just give us a few minutes to decide that, all right? Here's my instructions. You're not allowed to do any research on this case. Again, everything that you need to know about this case during the phase of this trial is to come from inside the courtroom. You're not allowed to start deliberating internally with yourself or with each other. Just don't even think about this case unless you're inside this courtroom. Does everyone understand? All right, so if you all will wait for me in the jury room, and I will come back there as soon as possible to tell you when we'll start tomorrow. Everyone, please rise for the jurors.
I don't know. I don't remember. I don't know what. No, I guess I don't.
A man who goes by the nickname Lil Woody might be one of the most entertaining witnesses we've seen so far in the RICO trial against rapper Young Thug out in Atlanta. And that's saying something. We have some of the top moments from Kenneth Copeland's testimony over the last few days. Welcome to Sidebar, presented by Law and Crime.
Okay. I'm in here trying to cook. So that was the penalty phase for this TK guy, right? I'm gonna go ahead and put on. I'm gonna go ahead and put on Keefe D, right? I'm cooking, so I'm going to put on Keefe D and let that run. Now, every moment of the courtroom wasn't. I got as many clips as I could from the argument with regards to his jailhouse fight. So, yeah, give me a minute. Okay, yeah. Let me put on Keefe D real quick. For some reason, I'm so winded.
The man accused in the murder of hip-hop legend Tupac Shakur giving his first interviews with 8 News Now investigator Vanessa Murphy. You're watching 8 News Now at 6. I'm Brian Loftus.
I'm Denise Valdez. Vanessa has been visiting him in jail actually now for months as he proclaims his innocence and insists he'll soon be released.
Dwayne Keefe D. Davis insists he was not involved in the murder of rap legend Tupac Shakur.
So were you there that night in that car? What was your role?
No, I wasn't there. I wasn't there at all. No car or nothing. I wasn't even in Vegas. They ain't got no proof I was in Vegas. They ain't got no gun, no car, no KPD, no nothing.
Shakur's murder, an unsolved case since 1996 when he was shot and killed near the Las Vegas Strip. As first reported by the 8 News Now investigators, Metro Police arrested Davis in 2023 after he wrote a book and gave interviews stating he passed the gun to the shooter.
I was just trying to make money.
How much money do you think you made from the book and the interviews?
Davis insisting he'd be released from jail since our first visit with him back in September. Clark County District Court Judge Carly Kearney set his bail at $750,000 with a requirement to know exactly where the money is coming from to make sure Davis wouldn't profit from the case.
I'm an American citizen. They act like I'm guilty before I get a chance. It's not Russian to say Iran. This is wrong.
He claimed he previously made an immunity deal with the federal government.
They violated all my amendments and constitutional rights. I'm never supposed to be put in jail for this. Never.
Well, they're pointing to the interviews and the book.
I didn't violate that.
And during our visit in January, Davis continues to insist he's innocent.
They ain't got me. They ain't got no car. They ain't got no gun. They don't have no forensics. They don't got me. They got everybody on video. Do they got me on video?
By our visit in February, Davis was also facing charges in connection with this incident in jail. During each visit from September through as recent as Tuesday, Davis insists he'll soon be a free man.
I ain't no flight risk or no threat to the community.
At the time of his arrest, Davis was living in Henderson, a grandpa by then who had fought cancer. Now he is charged in one of the most notorious murder cases in America.
A jury trial is scheduled for early 2026. Vanessa Murphy, 8 News Now.
And Davis's next court appearance is scheduled for June.
Yes, Your Honor. Before we begin, will everyone make sure that their phones are on silent or on airplane mode? Please. Thank you. Mr. Giacomo, stay ready for the opening statement.
Yes, Your Honor. Thank you. Dwayne Keefe Davis, you'll hear, is in lawful custody.
Your lavalier on.
My lavalier on that? Okay. Let's try that again. You will hear that Dwayne Keefe Davis is in lawful custody of the Clark County Detention Center on December 23rd of 2024. What you will also learn about Mr. Davis is he really likes to talk. And subsequent to this incident, he has made a number of statements on phone calls that are recorded out of the Clark County Detention Center. And here's what he has to say. I'm not going to play the audio because it's really hard to hear, and you'll have a detective up here who will be able to help you interpret somewhat of this. But some of the things you will hear is going to be, I got his, I wore his out. I get dirty, dude. Dog handles his business. I body slammed him. I'm proud of myself. And you'll also hear him say on December 25th, just 2 days later, I got him. I told him every time he sees me, he's got to get a lump. Oops. This is Unit 7CD, so floor 7, Unit CD at the Clark County Detention Center. This is an overhead view of the day room, and that's what we call the day room camera. On the right-hand side are the cells to 7D. So there's a variety of cells on this side. It will become somewhat relevant. There's a variety of cells on this side. Down in the corner, you can see at the beginning of this, there's a worker. Now, workers are different than the people that are housed at this particular location. It's a specialized unit. It's a unit called MIPC, meaning that each individual defendant is in a room by himself, except for the time he has free time. And when he has free time, he is out there without any of the other inmates from the unit. Mr. Davis and Mr. Hamilton are housed about 2 doors apart, so they can't have physical contact with each other. But you will hear both in testimony as well as Mr. Davis referencing it in the jail calls, that him and Mr. Hamilton don't like each other. And they chirp at each other below the doors over at the Clark County Detention Center. What you're going to watch is when you have cameras like this, they have the ability to be manipulated. So this is 9:26 a.m. on the 9:26 in the morning on the 23rd. And you will see the cameras will be able to be manipulated so that they can focus in on a various area later on. So the camera catches it all like this, but later on you can zoom in to see what's happening in any particular section. So what you see, this thing is jumping on me here. Go back one here. This is Mr. Hamilton being let out for his free time. There's an officer in this module, and he's supposed to be out here all by himself. And he's doing what's known as razor pass. So you will see Mr. Hamilton, he's going to go up to the sink, and I won't play it all the way through, but he's going to take his shirt off. He's going to start soaping up his head and his arms. And then he is going to turn around and wait for that officer who went into the seaside to do a round in the seaside, make sure everything's okay, to come back and give him his razor. When he is done waiting for the officer, he assumes this position. He's leaned up against the sink. He's got his hands in front of him. But problematically, the entrance I showed you is this door right here. People coming through that door can't see Mr. Hamilton by pure circumstance. What you will hear is that Mr. Davis happened to be coming back from an attorney visit at the Clark County Detention Center, and he's being escorted by an officer. And this is the camera from inside the day room. And you'll see Mr. Davis walking in, and Mr. Hamilton remaining there. When Mr. Davis gets to that pole and gets his first sight of Mr. Hamilton, you're going to notice certain things. You're going to notice Mr. Davis's head turns, locks eyes with Mr. Hamilton. You're going to watch, as you continue to watch, that he stares Mr. Hamilton down, but he also starts walking in his direction, not to this door right here, which is where he's supposed to be heading to go to his cell. You see he starts turning right at that trash can, and Mr. Hamilton is still sitting in the same position as he's staring at him. He's going to continue to walk at him, staring at him. And what you can see in this photograph is that's Officer Ari Kine. Mr. Kine is looking down at his hands, and you will hear what's going on is he has a little piece of paper that for every transport, there's a picture of the inmate, some information about the inmate, and the cell he's going to. So Mr. Kine, Officer Kine at this point, doesn't have any idea that that individual, Mr. Hamilton, is present inside that day room. He doesn't know anything about what's going on until you see him pick his head up on the video. because he's down looking to see what cell he's supposed to be taking Mr. Davis to. Now they start to square off on each other. Then Mr. Davis takes an aggressive stance, puts his hands down like this as Mr. Hamilton starts to walk on him. If you notice, right about here is where Mr. Officer Kine's head pops up, and he will tell you what he hears is, "What's up? What's up?" He thinks the first person to say "what's up" is Mr. Hamilton, and that Mr. Davis responds with "what's up." Now, unlike on the streets of Las Vegas, you run into a friend and you say, "Hey, what's up? What's up?" That's not what this was. Ari Kine will tell you that's a challenge. The two of them are squared off and challenging each other to fight. And then, if you watch the video, they just decide to go. Officer Kine will tell you he continues to give them orders to stop. When they don't stop, he begins pepper spraying them until he has help. They continue to fight throughout all this. It takes ultimately 3 officers to try and pull them apart as both of them continue to use force or violence upon each other. Eventually, they get separated. An investigation is conducted by the intelligence unit at the Clark County Detention Center, and both Mr. Davis and Mr. Hamilton get charged with the unlawful use of force or violence by a prisoner, as well as challenged to fight for mutual combat inside the Clark County Detention Center. That's this case. It's that simple. At the end of this case, we're going to ask you by your verdict to tell Mr. Davis what he did here was unlawful. Thank you.
Thank you, Mr. Johnson.
We're talking about the control system. You can come out of this picture. We're talking about the control system that waits to open their doors.
Correct.
You're familiar with that control system, right?
Yes.
You know how it functions. In that control system, kind of the eye in the sky, what is the purpose of them waiting to open the doors? We're talking about the control system. You can come out of this picture. We're talking about the control system that Good afternoon, ladies and gentlemen of the jury. My name's Carl Arnold. I represent Mr. Davis. Mr. Davis is not guilty of the crimes charged. Let's start with the easy one first. Page 13, mutual combat. Mutual combat is defined. Mutual combat is defined as this: previous concert and agreement. A person fights with another person. Highlight the word previous. Please highlight the word previous. The reason why I want you to highlight that is the state didn't meet its burden. What evidence? None of a previous agreement that these two were going to get down and fight each other. There's absolutely no evidence. We heard from the officer that listened to all of his phone calls. All of his phone calls since 2003. No evidence of that. We asked the officer, the supposed ex-detective that is assigned to investigations, the first person that testified, what was said under these doors? He doesn't know. No evidence. No evidence of previous concert and agreement. What we have is this gentleman, Mr. Hamilton, unlawfully hitting my client. As Mr. Brooks said, that's one thing all three of us agree on. Mr. Hamilton willfully and unlawfully struck and battered my client. Okay? This is why my client's not guilty of battery. He did not unlawfully strike back. They want to say the fight started, when my client's foot turned to him, etc. That's not when the fight started. And I was thinking about it. The evidence that we have is Mr. Hamilton was well aware that my client was coming to see me. He started to form the intent right then and there that he was going to get out and come get my client. Then he gets into the room. We'll go ahead and play the video. Gets into the room, does that. He's facing, like I said, towards the mirror, towards the sink. Goes and takes a look. This is when he knows. He knows right then and there that my client is getting ready to enter into that room. We'll play it again and see if we can pause it right there for you. Right there. He knows that the guy that just went to his attorney visit, the guy, for whatever reason, he doesn't like and he wants to attack, is about to come into that room. What does he do after? Go ahead. Not my words, ladies and gentlemen. It's not. It's this officer's words. That officer's words are evidence that you can consider. I didn't say it, he said it. He positioned himself behind the pole. You know why that officer said that? Because that officer is in agreement with the three of us. Mr. Hamilton's plan from day one, when he went into that room, when he positioned himself there, was for this to happen. And that's the attack of my client. Go ahead and stop. The most important exhibit in this whole entire trial is Exhibit 13. The state put it up there for you. And they want to show you the profile of the video where you see his hand balled up. But Exhibit 13 shows both hands down. This thing happened instantaneously, okay? It was super quick. Both hands down show an indication that I'm not an aggressor. There's a cop right behind me. I don't know what you're gonna do, but I'm looking at you because you just said, "What's up?" to me. Both hands are down. And this guy starts approaching him, and he's approaching him not like 1, 2, 3, 4 seconds. This is instantaneous. What is one to do? What one is to do is protect themselves. You have that right. You have that right by law. Okay? And so we go to the battery instruction. Number 11, and it says it's only battery if it's willful and unlawful. It's lawful if my client is standing his ground and choosing to protect himself. As you will see in the instructions in regards to self-defense, if my client was the initial aggressor, if my client was the one that said, "What's up?" first, if my client was the one that ran away from the officer and tried to attack Mr. Hamilton, he wouldn't be afforded this defense of self-defense. But that's not what happened. What happened is, again, my client turned, "What's up? What's up?" back to you. And then the fight ensued. It's a famous quote from Franklin D. Roosevelt in regards to World War II. And it says, "When you see a rattlesnake poised to strike, you don't wait until he has struck to crush him." Thankfully, that's what the U.S. did in World War II on both sides of the ocean. And that's what my client chose to do. And it's his God-given right to sit there and not be attacked by another individual. We turn to instruction 15. A bare fear of bodily injury is not sufficient to justify the use of force. This was not a bare fear. At this juncture, this individual is reared up. His hands are in a position where he can take a swing at my client. My client's hands are still down here, but he knows that this rattlesnake is poised and ready to attack him. And that's when it went into action. Again, these are split seconds. Instruction number 16. Again, it says that the right of self-defense is generally available is not to an original aggressor or to a person who has sought the quarrel with the design to force an issue. Again, let's look at the evidence. What is the evidence? Nobody knew that Mr. Hamilton was in the room. That's the evidence that we had from the officer. The officer said, "We didn't know that he was in the room." They were there for standing for a minute. The officer said there was no discussion about seeing Mr. Hamilton in the room. That's the evidence. Again, what evidence does the state have that my client knew that he was in that room? What evidence has the state given us to show that my client intended to hit this guy? They haven't given any. And it's their burden to do that. Go to instruction 18. If evidence of self-defense is present, and that's what we're seeing. This is your evidence right here, that self-defense is present. This man is lunging after him. We know that he's the original aggressor. We know he was waiting for Mr. Davis to round that corner, because it was his plan all along to come in and attack my client. And so my client, there's evidence that he needs to protect himself. Now the burden shifts. The burden absolutely shifts because we presented that evidence through videotape. It's up to the state now to give us evidence beyond a reasonable doubt that self-defense is not afforded to my client. They don't have that evidence because they can't sit here and tell you what were the thoughts that were going through my client's mind. What they're trying to do is saying, look, we have all these things he said about the fight, okay? But when did he say those things about the fight? After the fight. You all have either been in a fight or have heard when a person's in a fight, they're going to give the best version of what happened in regards to them. They're not going to say, yeah, man, he got me, beat the living tar out of me. That's just not what's going to be said. What's going to be said is, yeah, I got him, yeah. You know, we listen to other phone calls that Mr. Davis did, and he goes, oh, he only got one punch on me. I looked at the tapes. You guys don't have a chance to look at the tapes. That's not true. So that's not even good evidence. Out of my own client's mouth, they're going to use that as their good evidence? Fail. That doesn't work. It doesn't work. The state cannot prove beyond a reasonable doubt that my client did not act in self-defense. My client, pursuant to self-defense, can stand there, can take this guy approaching him and react. That's what you're allowed to do by law. Next, hasn't been argued yet, but it will be argued that instructions were given to Mr. Davis and to Mr. Hamilton to stop the fight. Decease, quit, stop the fight. Okay? And since they were given those instructions and they continued to fight, well, that takes away his self-defense. No, it doesn't work that way. Okay? Here's the thing. Self-defense goes to the person that believes they're in imminent danger. That's what the jury instructions say, okay? My client believed he was in imminent danger when he made that turn, saw that guy in the corner that said, "What's up?" and he's coming at him. Right then, my client knew he was in imminent danger. It's not what the officer does and says, "Oh, stop the fight. You guys break it up." No. All that is number one, the officer not interfering and stopping the fight. But number two, my client is still getting beat up on. At this time, you know, Mr. Hamilton has him turned on his back. Mr. Hamilton has the advantage. So again, what's going through my client's mind? The only evidence you have of that is the video. My feeling is you guys are really understanding the case, really understanding the law. And so I only have a couple more comments. The bottom line is this, that you have two kids at school fighting. Someone swung on the other kid first. The teacher is yelling, "Stop, stop." It's the same situation that we have in this case. There has to be someone that threw the punch first or initiated the aggression. And that's what we have from Mr. Hamilton. He's the initial aggressor. My client felt he was in harm, and my client had the right to protect himself. Go to the last line. This is mutual combat. Mutual combat, again, is a previous agreement. If you remember the scene from this movie, these guys came to the gym, took off their clothes, put on their boxing gloves, and said, "Let's do it. Let's do it outside of the audience of everybody else. Let's have this fight." There's no evidence whatsoever that the state has laid that shows that. That's mutual combat. We don't have any evidence of mutual combat in this case. We have evidence of self-defense, and we have no evidence that the state can provide to us that shows that he's not entitled to self-defense. So what does that mean? Not guilty. Please mark that on your jury verdict form, not guilty. Me and my client will thank you very much. We're talking about the control system. You can come out of this picture. We're talking about the control system that waits to open doors.
Right.
You're familiar with that control system, right?
Yes.
You know how it functions. In that control system, kind of the eye in the sky, what is the purpose of them waiting to open the doors?
They may not necessarily be waiting to open the door. They may be opening other doors and just haven't got to that door to open it yet. It goes in order so that when the button is pressed by that officer, it rings in the control room or lights up on their board that door needs to be open. So they open up systematically when they get to that particular one. So they might open fast because nobody else be pressing the doors, or it might open slowly if there's a whole lot of action going on throughout the jail.
Okay. And so prior to opening the doors though, are they supposed to make sure that that area is secure, like there's no prisoner trying to run out of the door?
Well, in some units, there's people out on free time, so those doors open when inmates are out. So not necessarily.
Okay,
No,
what about
in your
this
max units? Yes, but in a unit like this, no,
Why not in a unit like this?
not according to our policy.
What was the name of this unit again?
This is 7 Charlie, 7 David.
No, but you had a term for it.
The
Man's-
people, male intensive protective custody.
Male intensive protective custody. And what's the purpose of that room?
What do you mean with the purpose of it?
Meaning, sir, why are people housed in there?
Because that's how they've been classified.
And what's the classification that would cause them to be housed in there?
What are the criteria?
Yes, sir.
So when inmates come inside the jail, they go through a classification process. They're asked different questions. So their classification could be because institutional history, could be because of mental health history, could be because of their nature of their charges. They have a whole parameter, and these guys are questioned when they come in, and their classification is determined by that, and then they're housed accordingly.
And also, one of the classifications could be because it's a high-profile case.
Correct.
And so, again, the purpose of that room is to keep all these individuals separate, correct?
Correct.
And they're not allowed to be with the general population, correct?
Correct.
And that these people, because of the various classifications, they need to be separated from regular inmates.
Correct.
Okay. So they may present a danger to each other if they're not, correct?
Correct.
And so that room should be cleared before, well, let me rephrase that. There should only be one inmate at a time in that room. Is that correct?
Best practice, yes.
That's the practice. And there's any occasion where there should be two in that room?
Not necessarily there's multiple officers with those particular individuals, and they're separated by officers.
Okay.
There are occasions when they're going to court or going to an appointment where there are multiple officers that are transporting individuals, but those officers, there's more than one officer by himself with those inmates.
So the practice is that there are not going to be two guys in that room at the same time to sit there and watch TV or any other activity.
So our policy states that you can have two housed in the same unit together. Generally, by best practice, we generally don't. But it is our policy that you can have two individuals housed even in the same cell together.
Okay. But in this particular room, there should be an officer with that individual while they're coming through that room.
Best practice, yes, would be ideal.
And you said the one officer, I believe you called him the module officer.
Correct.
He left. Is that correct?
He's in the 7 Charlie side doing his visual check of that particular unit.
Okay. And we see him go off behind the door.
Correct.
Okay. And what's on the other side of that door?
24 cells.
Okay.
So it's just like, so the 7 Davis side where Mr. Davis was being escorted, there's 24 cells. On the 7 Charlie side, this same setup, you go through a glass door and there's 24 cells. So he was going through that unit to do a visual inspection of those units.
Why was he doing a visual inspection of those units while we had an inmate in there getting ready to shave?
Because those walks are required every 30 minutes, whether there's an inmate out or not. You still have to do those checks.
And so that inmate's left there unsupervised?
Yes.
Did, let me ask this. When the officer is getting ready to enter into the room like we see in the video here,
Okay.
does the officer have to push a button?
On the outside of the door, yes.
And that push of the button alerts the control people that someone needs to pass through.
Correct.
Now, do those control people look to see who's trying to pass through on the other side of the door?
Yeah, there's a camera that comes down on the outside that can see who's going in that side of the door.
Okay. And then does the camera also come back to the room to see if the room is clear?
That's up to the control room operator. I couldn't tell you what they do.
Okay, that's up to them. But I'm asking, part of your investigation should have been, can they look into that room to see if it was clear? Did you have that discussion with the control
We did
person?
not.
Well, wouldn't that be a breach of security if they opened a door with a loose, I'll call him a prisoner, with a loose detainee? I like that better. A loose detainee in there.
No, because per policy, they can open that door. It's not the only time they would probably want to make sure that that's it is if the inmate was a max inmate. Otherwise, they can open those doors freely if that inmate's out there.
So they can open their door and not know that someone could potentially, especially an officer, be in danger?
I'm not understanding why. How would he be in danger?
If you said that he was supposed to go in there for a shave, right?
He is, yes.
And with the shave, he gets a razor. Is that correct?
Correct.
So this person, the eye in the sky, the control officer, it opened that door, and this individual, Mr. Hamilton, could have had a razor in his hand, but you don't know, pursuant to your own investigation, that if the eye in the sky saw that or not.
Well, first of all, Mr. Hamilton wasn't given a razor yet. So the officer can freely go out there and not. When the inmate is given a razor, that officer always stays in that room with them and watches them while they have the razor in hand. They don't leave them unattended to go do their walkthroughs with a razor.
But we don't know Mr. Hamilton presented any threat. Well, the eye in the sky didn't know that, and he allowed an officer and Mr. Davis to come into that room without any kind of notification.
That's common practice.
You said as part of your investigation that they had words between each other. But you don't know what exactly was said.
Correct.
So you don't know what the words were. Could have been, hey, you didn't share with me your coffee. You don't know.
There have been numerous things. I don't know.
Or you took up my phone time. You don't know.
Correct.
In fact, you don't know if these individuals said, hey, if I ever see you on the outs, I'm going to get you. We're going to get into a fight. You don't know if that was said prior
I don't know what was said at that time. No, I don't.
Okay. So you have no information that you can provide this jury in regards to what was said between these two individuals prior to them having their altercation that day.
I could not tell you what happened that day.
And pursuant to your investigation, you have no information to know if Mr. Davis was aware that Mr. Hamilton would be in that room when he came back from his visit.
Correct.
Let me ask this. Do you have any information that Mr. Hamilton knew that Mr. Davis went off on a contact visit?
I don't, not unless Mr. Hamilton seen Mr. Davis leave the unit. I don't know.
Which is possible, correct?
Correct.
Because their cells are right next to each other, correct?
Pretty close, yeah.
And so Mr. Davis could have been inside his attorney visit, which obviously he was, when Mr. Hamilton was released from his unit, correct?
For his free time, you mean?
Yes.
Yes.
And he could have been well aware that Mr. Davis was out on a contact visit.
It's possible.
Real briefly, I want to turn my attention to Officer Kine. What is the purpose of the inmate being escorted by an officer to his contact visit?
Because he's leaving the unit. So once he leaves that unit and goes out, the officer escorts him to the contact visit. When they're done, they bring him back. In this particular unit, Mr. Khan appeared to be walking him back to his actual cell itself.
Is it not safe to just let him go to his contact visit and come back?
Well, I don't know what Officer Khan what his plan was, but apparently since he didn't see the officer in there and seen the officer walking through the other module, he was going to walk Mr. Davis back to his room, which is a common practice.
Okay. And again, are they just allowed to just go to their contact visit and come back to their room? You guys are in control of the doors, right?
Inside the unit itself, we control the doors, yeah,
Right.
the cell doors.
And the doors leading out to the attorney visit rooms, you're in control of those doors, correct?
Yes.
And it would be impossible for someone to escape because of these doors and how they operate. You just can't get through these doors.
No.
Do you agree with that?
Correct.
And so, couldn't my client just go to his contact visit and come back and go back to his cell?
By himself?
Yes.
No,
Why?
because it's on a different floor.
Okay, but he knows the way, right?
They are not allowed to they're not allowed to walk by themselves throughout the hallway.
Why?
It's a security thing. We never ask.
It's a
we always do.
security thing. That's correct. And so when the officer is bringing the my client back into that room, isn't he supposed to provide for his safety and other inmate safety?
Sure.
And he's reading a card at the time of this incident. So obviously, he didn't take the time to provide for my client's safety.
That's what's behind that.
But was part of your investigation that there was a breach of security there in that day room that day?
It was not a breach of security.
You feel everything?
I explained that you could have two inmates in the same cell that are in the same house, that are classified as the same. So it's not a breach of security. It's not a violation of policy. It's just the best practice if he would have maybe seen Mr. Hamilton, but that's not a breach of security.
Right. And but you also said the best practice was for them to both have been supervised or be escorted or watched by another officer.
If the officer was available, yes, it would have been a best practice.
But the officer chose to go do a watch as opposed to watch Mr. Hamilton, and then there was an allowance of another inmate coming into contact with the inmate that was unsupervised.
Mr. Hamilton can stand at the sink while the officer does it. There was no threat. He has to do his walkthroughs. It has to be done.
And
There's no threat of security.
And that's the point. He could have stood at the sink and nothing would have happened. But Officer Khan had his head buried in the card and didn't watch Mr. Hamilton come off of that sink.
Correct. But not a breach of security.
To about the 2-minute and 5-second mark. And I'm going to pause it. Gentlemen, the state calls Officer Ari Kine.
Officer, you stand, raise your right hand, and sign the right now. You do solemnly swear or affirm, under the pains and penalties of perjury, the testimony you're about to give in this action will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Please state and spell your first and last name for the record.
Ari Keim, Arikeim.
Officer Kine, how are you employed?
I'm a corrections officer for LVMPD.
And how long have you been a corrections officer with, and when you say LVMPD, what is that?
Las Vegas Metropolitan Police Department, and going on 5 years.
During the course of your time as a corrections officer, where do you spend your day-to-day work?
North Tower.
Is that here in Clark County Detention Center?
That's correct.
And the question, is Clark County Detention Center here in Clark County, Las Vegas, Nevada?
That's correct.
Were you working back on December 23rd, 2024?
Yes.
Do you recall an incident around 9:30 in the morning that brings us here to court today?
Yes.
Could you tell us a little bit about what you were doing and where you were headed when that incident occurred?
That day I was working overtime. That overtime spot is just taking inmates back and forth between attorney visits. And on that day, I was bringing back Mr. Davis from his attorney visit.
And when you say Mr. Davis, do you see that individual here in court today?
Yes, right there.
Could you describe an article of clothing he's wearing?
Suit,
Your Honor, could you be a little more specific?
tan suit.
Your Honor, let the record reflect that identification. When you were taking Mr. Davis, what room do you enter when the incident first occurred?
I was entering the 7CD, which is the module, the outside slider.
And before I ask you anything else, let me just, and Your Honor, was Exhibit 40 eventually admitted? Yes. Let me show you what has been admitted as Exhibit 40. Do you recognize Mr. Davis in this one?
Yes.
And who is it that you come in contact with next? So it's you and Mr. Davis, who do you kind of come in contact with next?
Rochelyn Hamilton.
Showing you been admitted as Exhibit 41, you recognize the individual depicted in this photograph.
Yes,
And who is it?
that's Rochelyn Hamilton.
Where was Mr. Hamilton when you and Mr. Davis come into contact with him?
He was located in what we call the inner day room at the sink.
Tell me a little bit about, are you aware of where Mr. Davis and Mr. Hamilton are housed and what unit they're in?
Yes.
Tell me a little bit about, and forgive me for this kind of poor characterization, but compare their housing to what I see in movies, where there's two people in a cell, where they go out to the yard and work out. Explain kind of the difference between that conception and there.
So they're in a unit called Male Intensive Protective Custody. And so they'll be housed in cells by themselves. They won't have cellies. They don't go out to a rec yard with other people in the unit. And basically the goal is to, as much as possible, minimize their exposure to other inmates.
And so the kind of dynamic that we always see in movies where people are working out or playing basketball, is that not what these inmates would be used to or be allowed to do?
Correct.
The interaction between Mr. Hamilton and Mr. Davis typically, would it be confined to them in their individual cells?
That's correct.
So pretty much just audio or talking to each other.
Correct.
Now, I want to take you through some of the videos we've seen with prior witness, but I want you to tell us a little bit about some of them. Showing you first Exhibit 1. And I'm gonna move to about the 2-minute and 5-second mark. And I'm gonna pause it. What are we looking at the 2-minute and 5-second mark?
So at this point, I'm standing behind Mr. Davis. Mr. Davis is entering the day room, the inner day room, and we're, making our way towards the 7CD or 7D side.
Now, we keep hearing 7C, D, and then 7D, 7C. Explain that dynamic to us. Explain 7C, 7D, and then the two together.
So the module itself is 7CD, but the unit is broken up into two sides. So on the left-hand side, you have the 7D side, and on the right-hand side, you basically have a mirror image of that unit on the other side there.
And this room that we're going into is that one that is shared between 7C and 7D?
That's correct.
So you can enter to this room from both, like both sides.
Correct. It's like in the shape of a Y. That's how I would explain that.
Would this be the center of that Y?
Yes.
What do we see you yet in this image?
I'm standing right about to enter the slider there.
Now, as we see, who is it that's in front of you?
Mr. Davis.
Is it customary or normal that Mr. Davis would be entering the door prior to you?
Yes.
Why?
Due to safety concerns, one of the big things is we don't allow inmates to walk behind us, just so they don't catch us off guard or try to jeopardize our safety.
So nothing about this is unusual as far as Mr. Davis entering the room.
No.
I'm going to go ahead and play from that point. I'm going to stop here at 2:08. Officer, what do you have in your right hand and what are you doing?
It's called a locator card, and I was looking down at the bottom of the locator card. It'll have their housing, so their unit and what cell number they are. So at that point, I was just looking down and confirming which specific cell that he was in on the 7D side.
And when you say he, Mr. Davis?
Mr. Davis, correct.
Would it also have a photo of Mr. Davis?
That's correct.
Now, when we saw you outside that door, and then even right now, did you have a good visual or a clear visual to the other person who eventually come in contact with?
No.
Can you explain why?
The way that I was standing outside the slider there, you can see that support pole that's there. That's like directly in line with the view of the sink from the slider.
As you're walking at this point in time, have you yet noticed Mr. Hamilton or Mr. Ashley? Do you know the other person in this room?
Not at this point.
Oh, so I meant, who is the other person?
Oh, yes, Rosalind Hamilton.
Have you yet noticed Mr. Hamilton in this room in real time?
Not at this point, no.
Now, is there any rule prohibiting you from looking at the locator card for Mr. Davis to know what cell to take him to?
No.
No, sometimes I mean, at full driving, they're not allowed. You can look at the card while walking, fair?
Correct.
Now, I'm gonna pause it here at 2:12, just 4 seconds later. What have you done at this point? What are you starting to do again?
I was looking at the locator card.
Have you yet noticed Mr. Hamilton?
At this point, no. As I round that pole there, I kind of noticed him out of my peripheral, and then
So I'm gonna play. You tell me to stop when in real time you either heard something or noticed something. Okay.
right there.
What did you hear or notice?
Rosalind Hamilton, he said, he basically said, "What's up?" to Mr. Davis, and he responded back with "What's up?" and then that's when the fight took place.
So Mr. Hamilton says, what's that phrase again?
What's up?
Did Mr. Davis say anything in response?
Yes, he says "What's up?" back.
So both of them just say what's up.
Correct.
When they say that, do you have time to register another person is in the room?
Initially, when I heard the other voice, that's when I recognized that.
Poor question. When I say register, have you yet had time to separate or do anything in between you?
No, at this point, we're fully inside the unit.
Explain to me we stop this, we use still photos. Explain to us the actual time elapsed between what's up, and contact.
I would say less than 2 seconds.
Now, what do you do? I'll press play after this, and you tell me what you did in real time when this happened.
So they start fighting. I radio that there's a 416 and 7 CD, giving them verbal commands to stop fighting. They don't stop fighting. I deploy my OC spray to attempt to get them to stop fighting, which they continue. Backup here arrives. I grab Mr. Davis. The other two officers are grabbing Mr. Hamilton. And as we're trying to separate them, they're both, still trying to grapple with each other. That's why you'll see a little bit of time lapse before they actually get fully separated.
Okay, I'm going to stop here at 250, this view. And while I go to the next view, I want to ask about something you said. You said that you holster your, what was that?
OC spray.
Why, is that why we don't see you go hands-on with the other two officers immediately?
Correct.
Explain to us so we understand why you have to holster something prior to getting hands-on with it.
So there have been previous incidents in the jail where people will.
Nothing to do with this case, right? This is just why you're doing it?
Correct.
All right, sorry. Go ahead.
There's incidents of that happen, in the past where people will just kind of place their taser to the side or toss it and just kind of get tunnel vision on what's happening in front of them. And, if there's other inmates around or even that inmate, that you're having a situation with could potentially get a hold of your taser or your OC spray. And obviously that causes safety issues.
So is that why you have to holster that before getting with the
Correct.
Eventually, do you and the other officers go hands-on?
Correct.
While going hands-on, do Hamilton and Davis separate?
Not initially, no.
What do they continue to do?
They continue trying to throw strikes and grapple and hold on to each other.
I'm going to move to Exhibit 4, which is just kind of a zoomed-in version of what we just saw. Playing from the beginning. Officer, do you have a mouse there in front of you?
Yes.
Could you wiggle it, see if it's on? Let me, you're on the approach your home. tell us where you and Mr. Davis were headed initially.
So initially, we're headed to this door right here, 7D side, where Mr. Davis was housed.
Are you looking up or down at this point?
At this point, I'm looking at the locator card.
You're not playing on your phone or your watch, you're looking at the car.
Correct.
Does Mr. Davis continue with you to the door, or does his progress change?
It starts to change at this point. He starts to kind of turn towards Mr. Hamilton, which you can see by the way his stance is starting to change here.
Now, is it fair that you can't get inside Mr. Davis's mind and tell us which direction he was going?
Correct.
However, when looking at his body, are you able to tell he's no longer at least progressing with you?
Correct.
Officer, I'm going to pause it and just go back briefly to let's go to the 5-second mark. As best as you can remember, has what's up been said yet?
At this point, I believe that's when Mr. Hamilton initially said what's up to Mr. Davis.
And when Mr. Davis responded, was it close in time, immediately? Explain that to us.
It was immediately after.
So if I play for about a second, has Mr. Davis already responded?
Correct.
And what's our timestamp down there at the bottom as far as in the video, right here?
It is at the 6-second mark.
Fair, so then fair, it's within a second or so.
Correct.
And then, so ladies and gentlemen of the jury, understand, could you read to us the timestamp on the actual video from Clark County Education Center?
9:28 in the morning.
Does that correspond with essentially the 9:30 shift you discussed?
Correct.
I'm going to go ahead and let it play. And just so that we kind of understand, who is it that it has a shirt on and who is shirtless?
Mr. Hamilton's the one without the shirt, and Mr. Davis is the one with the CCBC blue shirt on.
So at this point in time, at least as I've stopped it, who is on top of who?
It looks like Mr. Davis has partially got the upper hand here.
Is it fair that will switch throughout?
Correct.
The fight?
Yeah.
What are you doing? Are you just wiggling your finger here?
No, at this point, I'm deploying my OC spray.
Are you doing anything contemporaneous with deploying the OC spray?
I'm sorry, could you reword
Have you
that?
said anything out loud?
Verbal commands, yes, telling them to stop fighting or they'll be sprayed.
Now, I know we're kind of using inside for appropriate voices. Are you saying it in a normal tone, or are you doing something else?
No, I was yelling it.
Do either of them respond to your yelling and ordering of commands?
No.
Could you tell us, and we've all told you to the exact words, but could you tell us some of the phrases that you would say in a situation like this?
Basically tell them to stop or you'll be sprayed. And then usually when we're spraying, you might say OC spray or.
Do you issue verbal commands to stop prior to deploying the OC spray?
Correct.
So you give them the chance at least?
Before and during, correct.
While spraying the OC spray, does that cause the two to stop fighting?
No.
Does it, and just for fairness, fair that neither Mr. Davis nor Mr. Hamilton stop?
Correct.
Are you spraying both of them?
Correct.
Why are you spraying both of them?
They're both displaying assaultive behavior with one another.
Playing. Who now has control?
At this point, Mr. Hamilton's on top.
If you could take the mouse and just kind of like trace Mr. Hamilton's legs and Mr. Davis's legs.
So Mr. Hamilton's legs are right here. And then Mr. Davis, he's got his right leg here, kind of wrapped around Mr. Hamilton. and then his other leg is positioned underneath him.
As Mr. Hamilton is, we'll see, throwing punches with this right hand, does the act of punching enable Mr. Davis to do anything? I'll press play.
It basically enables him to encircle his arm around Mr. Hamilton's neck in order to kind of, let's say, like roll him off of him.
So is it fair that almost each inmate, as they're getting punches in, give up kind of the control?
Correct.
I will stop it here, about the 43-second mark. When multiple officers end up pulling the two apart, is it easy to detach the two?
No.
Have they obeyed the commands from the other officers when they show up?
After they were separated, that's when they were following commands.
After separation?
Correct.
Tell me now, when they were separated, so we understand, did either person have any weapon in their hands, any razors in their hands, knives, shanks, all that stuff?
No.
Was it just a fist fight?
Just a fist fight.
We had heard Mr. Hamilton was in there for possibly shaving. Does he have a razor?
No.
Showing you a portion of Exhibit 3. I'm actually going to go back real quickly, officer. And so when we start the fisheye here, okay, I'm going to pause it at the 4-second mark. Just because we don't have another view of this, tell us what we're looking at here before we go into the room.
So this is the 7D side. This is what we would call the outer day room. So behind each one of those numbered doors is where individual inmates would be housed in.
So 10 is an individual person, from 11, from 9, from whatever.
Correct.
And so is this the room that you were headed into?
Correct.
Do you recall, as you sit here today, which cell Mr. Davis or Mr. Hamilton were in?
No.
I should ask you this. The card, the locator card, is it fair that throughout someone's time at CCDC, they might move to different cells throughout their time? So you can't always just say, oh, that person's 722.
Correct.
I'm going to fast forward here to 1 minute and 10 seconds. Are we able to see you at all in any part of this video?
Yes, I'm located right at this point in the slider, and Mr. Davis is located to the left side here.
So are you just looking for your key card to open up the door? What's happening here?
So at that point, I'm just standing, waiting for control to open the door because we don't have access to opening those doors.
Explain that to us.
Control or?
Yeah. So explain that you can't just open this door.
Correct.
What is control?
So control, they're an entity within the jail, and they control any kind of freedom doors or exit doors to modules. And there's a button next to each one of the sliders. So when you press the button, it'll make like a ring sound on their end. And then that's when, they'll check, one of the cameras, make sure it's an officer standing at the slider there and unlock the door.
So before you enter, we were kind of pause here. Are you able to have a clear view to that safe on Mr. Hamilton?
No.
Again, use the mouse, show us what you can. Show us what's in here.
This support pole right here.
So I stopped it at 206. Is it fair that this is now just the opposite side of the other view that we had been seeing?
So at this point, I'm looking at the locator card located in my right hand there, and Mr. Davis is making eye contact with Mr. Hamilton.
Do you remember previously when I said, does Mr. Davis's path change or veer from the 7D door?
Yes.
Is this that moment in time?
Yes.
Show us, if you could, with the mouse, where was the door that you guys were intending to head towards?
We were intending to go to the 7D side door right here.
Show us where Mr. Davis's feet and head is pointed, with what direction out.
His right foot, you can see he's stepping towards Mr. Hamilton here. And you can see that his gaze is no longer at the door; it's directly towards Mr. Hamilton.
Fair to say Mr. Hamilton is also directing his, at least where his eyes would be, towards Mr. Davis.
Correct.
Have you yet heard what's up, what's up?
At that point, I heard that from Mr. Hamilton, and then within less than a second, Davis said it after.
So around this point in time, you're saying?
Correct.
Okay. So I'm gonna press play. Have you started your radio for help?
Correct.
Okay, I've frozen it at 218. When we see the officer in the upper left portion of this video come, where is that person coming from?
He is coming from the 7C side.
And now, where will other officers come from? What direction? Or doors?
They'll come from either the slider here that control has open, or what we like to call the bubble, which is where only officers are authorized to be in, which separates that from a different unit on the other side.
Have you, at the pause of the 2-minute, 27-second mark, have you guys gone hands-on to attempt to separate?
Correct.
Have the two inmates separated?
At this point, no.
Are they continuing fighting, grappling, whatever term?
Correct.
Eventually, they're able to be separated,
Correct.
and I will pause it there and go to Exhibit 4, which is just a zoomed-in excerpt of that. Let me know when you see yourself enter screen.
There.
It's fair that you've watched this video multiple times.
Correct.
Are you ever able to tell us who strikes who first, who, had a higher lean towards the other person?
Not really. They both, pretty much showed assaultive behavior right off the bat, which assaultive behavior for us doesn't necessarily have to be throwing an actual strike. It could be just balling up your fists, taking a fighting stance. That's how we define assaultive.
Can we ask you that then? I just want to back up. And we'll pick on both guys here, just for this purpose.
Correct.
If I pause it, let's just say right now. Let's pause it here. I know we can't really see either guy's hand in this motion, but let's pretend Emmett Hamilton's fists are completely bald and you see it. What would you do?
I would treat that situation as assaultive. So I have different options that I could do. I could either go hands-on, OC spray, taser.
If you had seen even the balling though at this moment, would you get in between those two?
Correct.
And let's say again, when we get the officer or Inmate Davis's hands had been balled right here, would you also try to get in between the two?
Correct.
videos I want to show you is just attempt to kind of sync the two views together. And they're much shorter, showing you exhibit 5. Do you have any time between the phrases what's up, to get in between the two images?
No.
Showing you exhibit 6. Officer, I'm going to go to exhibit 12. This was kind of the moment I was poorly attempting to freeze frame just a second ago. When you look at Hamilton and Davis in this position, how would you describe this?
I would describe them both standing in what would be considered an assaultive position.
And then in exhibit 15, so the time difference between 12 and 15, has the phrases been exchanged by both?
Correct.
Lastly, in exhibit 26, is this, what are you doing in exhibit 26? Did you describe this to us earlier?
I believe at this point, that's where I finished radioing, just giving verbal commands while simultaneously reaching for my OC spray, which is on my back right side.
And sorry, lastly, if we go to exhibit 30. Where are you spraying the OC spray, and who's one person's body part in the directionality of the OC spray?
So at this point, I'm attempting to spray them, try to get it on their face and their eyes, because that's usually what causes the disorientation, and with the goal of them stop fighting. But due to them, rolling around and moving around and it being a dynamic situation, it's kind of getting on the floor, it's getting on their face, getting on their clothing.
While we're waiting, Mr. Arnold, which jury instructions did you object to?
There were only the self-defense ones. I didn't see any authority on, I think it was 19 and 20 on. Yeah. And I think they were basically trying to imply that if you continue the fight, you have to cease and desist at some point, or there's no self-defense. And again, I haven't seen any case law on that.
So when I'm looking at the self-defense instructions, I see it starts at 14 and ends at 20.
I can tell you that all but one, and the one we had footnoted, Mr. Perkle, if my footnote is from a case on mutual combat, are from Runyon, except for Runyon is a death. So we had to amend them to non-mortal combat. So let me go to 19.
It's like the last two.
Yep, that is directly from, 19 is directly from Runyon.
That's the clear and present danger.
No.
If person uses force against another. Yeah,
That's not the one you're complaining about?
oh, you added this. And in good faith endeavor to decline any further struggle before the force was given.
Correct, and then Runyon it says, and decline any further struggle before the mortal blow was given. I didn't think we could use the term mortal blow. But those are the self-defense instructions from Runyon that are required to be given.
Yeah, it just didn't follow the pattern criminal jury instruction. It doesn't have that additional language in the pattern instruction.
It's in Runyon, so I don't know what the pattern says, but.
In good faith endeavor to include any further struggle before the force was given.
So far, senior citizen armed presence receiving violent harm, use of force is absolutely necessary. And the person upon which force was used is the assailant, or that the assailant had really any good faith endeavor to decline any struggle before the mortal blow was given is how it's treated. Has really in good faith.
Endeavor to decline. Okay, I don't object to that. I thought it was referring to my client, who was obviously not the assailant.
So this is. And then 20 is directly from the case that's still good law, Willamette v. State. In mutual combat, you don't have the right to self-defense with an open treatment.
Person who voluntarily entered into yeah, I was just wondering where the authority was on this.
There's a footnote on the bottom.
Woman. I just want to look at that case, Your Honor. The 19, after I reread it, I don't object. I just want to make sure Woman says that. I'm sure it does.
By the intelligence unit at the Clark County Detention Center, and both Mr. Davis and Mr. Hamilton get charged with the unlawful use of force or violence by a prisoner, as well as challenged to fight for mutual combat inside the Clark County Detention Center. That's this case. It's that simple. At the end of this case, we're going to ask you by your verdict to tell Mr. Davis what he did here was unlawful. Thank you.
Thank you, Mr. Johnson.
You can play it. On December 23rd, 2024, 2 days before Christmas, I decided to go visit my client, wish him a Merry Christmas, tell him about things happening in a pending case of his. That was the attorney contact visit. They escorted him back to the cell, and he didn't know that Mr. Hamilton was present. What you will hear is nobody else is supposed to be present in that room. What you will see in this video is Mr. Hamilton becomes aware that Mr. Davis, who is waiting at the top of the screen in the center up here, is waiting to enter into that room. The officer already left the room, and Mr. Hamilton is not supervised. After he lathers up, he's going to notice that Mr. Davis is at the door. You see him step over there? And instead of sitting down in the chair that he pulled up, he gets into a position where he can't be seen. He's laying in wait at this point. He's laying in wait because he knows what his intentions are, and his intentions are to attack my client. My client cannot see him. As the state said, the officer couldn't see Mr. Hamilton. He's being blocked out by that pillar. My client comes walking through, and then he notices Mr. Hamilton. And then they engage in a fight. I'm gonna ask you to pause at the shot right before they engage. You'll see that my client notices Mr. Hamilton. Mr. Hamilton came and moved quite a distance from the sink to Mr. Davis, who at this time doesn't have his hands up. This guy is poised, ready to strike. The officers totally unaware of what's going on, and this man goes to strike my client. What was my client supposed to do? What everybody has a right to do: stand their ground and defend themselves. And that's exactly what he did in this case. He had no clue whatsoever that Mr. Hamilton was there or ready to attack him. And my client is coming in with the officer, an officer right behind him, and as far as he knows, is watching his every move. He's not going to engage into a fight knowing that that officer is right there. Mr. Hamilton, on the other hand, does not care. And Mr. Hamilton goes and attacks my client, and we are saying, yes, there was a fight, but it was a fight that Mr. Hamilton started. He was the initial aggressor, and my client, by law, has a right to defend himself and stand his ground. And like the state says, that's the case.
We're here because on December 23rd of 2024, the following took place. That basic. But we're going to talk about the instructions that were just read to you, the facts and the elements of those instructions, and what you've seen in the videotapes. Now, some of you might be sitting there saying, well, what about the other guy? What about the other guy? You have an instruction there, and you took an oath to follow the law, which is you're here to determine whether the defendant is guilty or not guilty from the evidence in the case. You're not called upon to return a verdict as to whether another person is guilty or not guilty. So if the evidence in this case convinces you beyond a reasonable doubt of the guilt of the defendant, you should so find, even though you may believe one or more persons are also guilty. But throughout the course of today's arguments, I submit to you, probably all three of the people, me, Mr. Arnold, and Mr. Giacomo, will tell you Mr. Hamilton is guilty of the same charges. And we're going to go through that. We're going to look at the same elements and apply them to both at times. Now, during voir dire, there's a really interesting comment that one of you made. And the question was, how do you discern two versions of events if you don't know the people and they tell you, I think in that context, it was kind of verbal stories. They tell you two versions of events. How do you discern, which one is telling the truth, which one's not? And the answer was, whomever sounds more wrong. So it struck me, and as I was thinking about that today, I wanted to highlight that because that's an unusual dovetail into this instruction, because this instruction right here, you don't have to determine who's more wrong. We're going to tell you all day today. I'll submit you both sides. You'll hear it from different times. Both are wrong. So you need to look at the law and the elements and see if it matches what you've been given. So at no point today, some of you might be sitting there saying, who threw the first punch, whose skin touched right before the other person, or maybe who won the fight. Maybe you're looking there and kind of grading it like a boxing ref. No one is ever going to ask you to make a determination between Mr. Hamilton and Mr. Davis. To admit you, Mr. Hamilton is guilty of battery by prisoner and challenge to fight also. But that's why on the front of that packet, it is the state of Nevada versus Dwayne Davis. Because those are the charges. Those are the elements. I know a lot of times we watch television and we see that line. I always cringe a little bit when I see it, where during the course of some Lifetime movie, the person says, "Oh, I want to press charges." I don't know what that means. I see it all the time, but there's not a situation where it's Hamilton versus Dwayne Davis. It is laws enacted by the state of Nevada, and whether or not a defendant's conduct meets those laws and those crimes. So in getting into essentially the laws and the elements, let's look at first just how defendant characterizes what occurred in his own words. So just kind of, how does he characterize it? They released the video of you. That was the line that's said to him. He says, "Did you see me get him?"
Hey, release the video you called. Little bit, but you coming up like that too, in your head.
So Mitchie, that's actually a pretty fair kind of recitation of what happened. Yeah, a little bit, but he got you too. Yeah, it's because it's mutual combat. So let's look at what battery by prisoner is. First, we'll go through the elements of battery, and on my kind of job as the first closing is to give you a little kind of like a law lecture. So those are the instructions, and no matter what I say, those instructions are what govern. Her Honor gives you those instructions, that's what applies. I'm here to take some of the facts, some of the video, and then highlight some of the elements and explain different terms, why things might be there, what those mean. So what is battery? It's a willful and unlawful use of force or violence upon the person of another. Now, the force need not be violent or severe and need not cause bodily pain or bodily harm. So some of you might be wondering, hey, why didn't anyone say who got hurt, who was bleeding, who had a bigger bruise? It's because that's not an element of battery. Now, throughout the course of this closing argument, I will tell you about what is not elements. And that's because if you think about yesterday, during voir dire, over and over, you heard the state has the burden of proof for each and every element of the crime charge. Now, we always kind of focus on the state has the burden of proof beyond a reasonable doubt. But have you ever noticed we usually don't talk about what it is that the burden applies to? Well, the burden applies to those elements in your instructions. So that's why a lot of times in those same instructions, you will have things that are not elements. Likewise, if something's not in your instructions, it's not an element of a given charge. So I might highlight that. It's an intentional and unwanted touching. Now, we'll come back to the willful and unlawful because you have another kind of instruction on that. But just so no one kind of gets confused about this, at no point is someone going to stand up here today and say, hey, challenge to fight. If the challenge is accepted, then it's a wanted touching. That's not what that means, okay? So that phrase, intentional and unwanted touching, if someone, I'll give you an example. If you're in an elevator, you guys are in a crowded elevator, and someone kind of has a seizure and involuntarily hits you, it wasn't willful, essentially. It was an involuntary spasm hits someone. So it wasn't also intentional. Now, this one, it's intentional and unwanted. Don't confuse challenge to fight with wanting it. Just because you accept the challenge doesn't mean you want it. Force or violence upon the person of another. Force or violence need not be severe. Now, what is also not in those instructions? There's no requirement of pain of a body part used. You don't have to hit with a fist. You don't have to kick. There's not a number of times struck or how hard it has to be. By prisoner. This one's pretty straightforward because you saw a video of CCDC, but I'll just kind of take you through because I'll give you an example about why this instruction is the way it is. So if battery and the defendant was a prisoner in lawful custody or confinement, I submit to you, he's in lawful custody or confinement over at the Clark County Detention Center. You're not going to hear that that's not the case. A prisoner includes any person held in custody under process of law, lawful arrest, or deprived of liberty, kept under involuntary restraint confinement. So that's just a situation like, for example, lawful arrest. If the cuffs, out on the street, an officer actually gets a hold of a suspect and actually puts the cuffs on them and they're on them, that person is now detained and under arrest. If that person were to kick, punch, boom, that would actually now fall under this battery by prisoner situation if the cuffs are actually applied and they're taken into custody. And so that's why there's different levels of that. If you're looking at that and wondering, well, this one's in the jail, it's pretty straightforward. Yeah, there are times when it wouldn't be as straightforward. Now, I want you to think back also to yesterday during voir dire. And even during a lot of your questions today, a lot of the jury questions were good and reasonable, questions that you would be thinking. And that's because you don't actually have the elements or the instructions on the laws. Sometimes yesterday we spent time saying, okay, well, there might be different rules inside the detention center. You might have two bad choices, fight, or you could get punked, things like that. But if the instructions don't give some exemption for kind of two bad choices, do I fight? Do I run behind the officer? Do I say, put my hand up? And then someone tells how bad I look during this interaction? No. The elements of battery don't have that exemption. So it's reasonable that you asked a lot of those questions. Similarly, when we talk about like the control room and things like that. But if it's not an element of battery, then it is not to be applied by you when looking at the facts. What is willful? Willful and unlawful use of force. This kind of dovetails with what we were just talking. So willful is a purpose or willingness to commit the act in question. So it does not require any intent to violate the law, to injure another, or to acquire an advantage. So let's say it's that situation where, hey, no inmate wants to act like they're scared of a challenge. That is not an exemption. If the act of moving forward with your body, touching the other person with your body, hitting them, the grappling, the fighting, then the elements of battery are met. You don't have to intend on, hey, I'm going to make this contact and it is going to be a violation of the law. And I hope to injure that person or acquire some advantage so that people think I'm tougher around. It's not an element. Likewise, there's no exemption for both people wanting to fight. Hey, both people want to, it's okay. No. Commands are being given, pepper spray is being used, multiple officers are attempting to pull Mr. Davis, Mr. Hamilton off each other. And it's actually pretty fair as far as who got in blows, who got in fights. Realistically, this is a pretty good example of how once you start throwing punches, you kind of lose the advantage of holding body weight on the other person, and they flip you over, they get a turn. But this is mutual combat. The elements of battery are met. Now, you have an instruction there. Some of you might be saying, yeah, but why? Why did this happen? What was that chirping underneath the cell doors that you heard about? What was this prior discussion? Now, motive, what prompts a person to act? What prompted this fight? This what's up, what's up? It's not an element of the crime charge. So you have that as one of the very first instructions. The state's not required to prove why it is they fought. Now, motivation or whatever that previous talking shit was that was referred to, it's not an element as to what they were talking about. Now, this is the first call from December 25th, 2025, when Mr. Davis is just out of the hole. any battery type situation like this, we're going to now transition to self-defense. We're going to go through a series of instructions because the law on self-defense has several instructions. And at the end, I'm going to tell you why self-defense is not applicable to the situation that you have watched all day today. So what is self-defense? It's willful and unlawful use of force or violence upon a person or another. That use of force in self-defense is justified and not unlawful when the person who uses the force actually and reasonably believes imminent danger that the assailant will cause him bodily injury. So look at Mr. Davis, look at Mr. Hamilton. No imminent danger there. And it's absolutely necessary under the circumstances. It's not absolutely necessary that Mr. Davis here starts veering towards Mr. Hamilton. Now, at no point when I discuss Mr. Davis's actions, I'm excusing Mr. Hamilton's. It's mutual. Like, so just right now, the fact that Mr. Davis starts veering towards him and Mr. Hamilton's still leaning up against the thing, Mr. Hamilton walks towards him a second or two later in this. But what I'm saying is there's no imminent danger. This isn't absolutely necessary. There's a man in there with a taser, with OC spray, a guard who could separate these two, who could provide either one safety. A bare fear of bodily injury is not sufficient to justify use of force. Circumstances must be sufficient to excite the fears of a reasonable person placed in a similar situation. The person using that force must use that force under the influence of those fears and alone, not for any other purpose. So you can't use the situation to your advantage. You can't kind of create the situation and use it to your advantage. We'll talk about that here. So Mr. Davis, when he's discussing what occurred, what does he say? Big dog handles his business. I'm proud of myself. He got back, the guy who kept chirping and talking shit to him. The right of self-defense is not generally available to the original aggressor. I am not going to tell you either one is the original aggressor here. They move in unison. Look at those photos. Look at that video. Look how the body language mirrors them. Look how the words even mirror each other. What's up? What's up? So the person that sought the quarrel with a design force. Now, this next line, and create a real or apparent necessity for making an assault, that, don't get confused with that. That's a situation where if you provoke and cause a situation where, oh, now I'm actually really in danger and need to use self-defense, you can't create that and now take advantage yourself, all right? So either real or apparent. But here's kind of the key with regard to this instruction with what we've seen. Without voluntarily seeking, provoking, inviting, or willfully engaging in a difficulty of his own free will, they go at the same time. There's no one who has an advantage over the other one. Look at how both of them split the fight. They split the aggression towards each other. We saw this photo earlier today and discussed as though Mr. Davis kind of, I don't remember quite how it was discussed as far as, not that he was taken off guard, but he was just standing there. He's completely turned away from the door, away from the officer. This is not a situation where he is standing there in a totally defenseless position. What do I mean by that? Let's look at this moment in time as it actually occurred. It's a great screenshot from Mr. Davis, hands down. Now you heard his fists were clenched, but his hands are down. Let's see how long this lasts in real time. Ready? Let's go back, because that was longer than I expected since it paused. There it is. There's just, it literally is a transition from bottom to top. Let's look at it again. The screen, the still images on the right. Up at the top, in unison. One more time with the staggered view. How does defendant characterize what occurred in his own words? Why? I got in fights. With who? The little dude. I body slammed him. His name's Rob. I don't know if he's calling him Rock, but you could see how someone might get that nickname from Roshan Hamilton. What else did we have? Why'd you get in a fight? What did he do? Trying to rush me. He's just been talking. So it wasn't a discussion about sharing coffee. That we had a question earlier as far as like, oh, you don't know what they were talking between the doors. It wasn't coffee. Self-defense. A person has a right to defend from apparent danger to the same extent as he would actual danger. If in his mind an honest belief and fear that he is about to suffer bodily injury, and he acts solely upon these appearances and his fears and actual beliefs, and a reasonable person in a similar situation would believe himself in like danger. Last kind of one we'll go through here. The appearance of danger must be so urgent and pressing that in order to prevent his receiving bodily harm, the use of force is absolutely necessary. I wouldn't say necessary, absolutely necessary. So when self-defense or evidence of self-defense is present, the state must prove beyond a reasonable doubt the defendant did not act in self-defense. You have one other instruction after that, and I submit to you that that other instruction carries the entire burden, especially with regard to the self-defense situation. What does that say? It says a person who voluntarily entered into mutual combat is not entitled to rely on self-defense or the no retreat rule. So if you engage in mutual conduct, if you accept the what's up, and you're both involved in it, you don't get to later say self-defense. You don't later get to say, oh, I just wasn't retreating, I was standing my ground. Now, just to kind of clear up one thing, and I'm not in any way suggesting that this was Mr. Arnold's kind of contention here, but some of you guys might go in the back and wonder because it was thrown out. Mr. Arnold asked an officer, hey, isn't it true that Roshan Hamilton was also charged with mutual combat? Don't be confused by the question. There's no charge of mutual conduct. That's not what Mr. Arnold was referencing. He was kind of referencing charged with kind of the same crimes. There's not a situation where mutual combat is the charge you're looking for to negate self-defense. Mr. Arnold was just using that term with regard to what happened in the video, which is reasonable. Fight continues. Orders are given by an officer. Pepper spray is used. These two men do not stop. 3 officers are trying to pry them away. The grappling, the fighting, the punches continue. The use of force is not, even if it was necessary at the beginning, which I submit to you it wasn't, it's not necessary when 3 officers are trying to pull you apart and can't for roughly 7 seconds as you continue. You're not in danger. Now, you heard kind of that Mr. Hamilton positioned himself behind a pole. Is he behind the pole or is he at the same sink that he was at? Look where Mr. Davis is and Mr. Hamilton is still at the sink. Isn't there a better place to hide if you're going to hide behind the pole? Wouldn't you get actually behind the pole? Do we know if Mr. Hamilton thought, I wonder if that's the guy with my razor? Or was he just sitting there waiting to get his razor so he could shave his head? Or he was hiding Is he hiding from Mr. Davis or from the officer? Because Mr. Davis sees him the whole time. He's not hiding from Mr. Davis. We heard the term lying in wait several times. It's a legal term. You don't have a lying in wait instruction in your instruction packet. He's not hiding behind that pole and waiting till the opportune moment of Mr. Davis to walk by and hit him on the back of the head. This is face to face. You don't say what's up to the person you're hiding or lying away from. You don't go face on and say, what's up, and then begin. That's not what lying in wait is you hide behind bushes somewhere and then ambush somebody. Now, we'll look at this just because. So we'll look at a minute or so of this. The officer leaves. Mr. Hamilton is still by the sink. Takes off his shirt. Soaps his head. See Mr. Davis with the officer at least over there, still soaping the head, getting it ready, waiting for the razor. At this point in time, Mr. Hamilton does at least notice something at that door. He walks over there, sees, it's a door that's see-through, so you can probably see on the other side. Is he looking and immediately noticed it was Davis? Is he looking for his razor? Does he go anywhere? Does he hide? Does he crouch down? Does he just stay at the same sink that he's at until right before the moment both people go at each other? Challenge to fight. Let's count two. If upon previous concert and agreement, a person fights with another person. So let's look at this because I'm facing you. I might clench my fists. I might be nervous. I might say what's up to someone in the hall. But you, as ladies and gentlemen, the jury, get to determine what the evidence actually means and what the intention was between these two. And you get to use circumstantial evidence as well as direct evidence. So that posturing that you heard the officer say, that's assaultive, can't remember his word, but assaultive posture, or I would try to get in between the two. That's what that is right there. That's what that puffing of the chest of both men is. What's up? What's up? Language mirroring each other. I told him, I got him. I told him every time he see me, he have to get along. Mr. Arnold's completely right. Mr. Mogg, Detective Mogg is not going to be able to tell you whether or not he said that before the fight, after the fight, screaming it during the fight. But what does it also tell you? It tells you the exact same thing that we kept talking about today is when they see each other, they know it's on when they had that opportunity. Listen to that phrasing again. And that's what he did. Saw each other, had the opportunity, took it. Intention and what they meant by those phrases, those posturing, you can look at the video. You don't have thought bubbles that we kind of walk around with all day long that tell us our internal thoughts. But intention, it's a question of fact that you, the jury, gets to infer from defendant's conduct and all the other circumstance and evidence that's been given to you. So, one of the things that I always point out is circumstantial evidence, the law makes no distinction between the weight given, either direct or circumstantial evidence. So the phrase, what's up to you, and what it meant, and the actions and context in which it was given, you get to apply the same weight to that as you do the first punch, the first struggle, the first headlock, the continued fighting on the ground. Now, what are you not going to find anywhere in those instructions? Because some of that's going to be important as to refocusing as to what the elements are. You're not going to see a single thing about best practices of Clark County Detention Center. I don't know what they are, but at no point in those instructions does if best practices were not given on December 23rd, 2024 at 9:30 a.m., then it removes the elements of battery. That's not there. What's the common practice? Was this a breach of security? Those lines were thrown out and effective. I mean, that is what Mr. Arnold should do. So me pointing this out is not to disparage, or it was very effective. Now, it's the state's job to remind you about what the elements are. Those aren't in there. Look, is it best practice to lock your doors at night or to have a deadbolt on your home so that someone doesn't break in? Yeah, it is. But that doesn't negate the elements of breaking into someone's home. The officer doesn't show up at your house and say, hey, did you lock your door last night? Hey, your car was stolen. Did you paint that red? Because we have had a rash of car theft. No. Those crimes have elements applicable to them. And what happens in someone's home, whether it's locked or not, is not one of them. We kind of went over this card, but I'm going to point it out just because I'm also going to point it out under the concept of, how no one was hiding or lying in wait. Because in order to be hiding or lying in wait, Mr. Hamilton would have had to accurately predict the exact moments in time when the officer would be looking down at a car and happen to look up when there's a pole and then look back down. He would have to guess that spot on. So let's look. Mr. Davis has complete line of sight. The officer's looking at the car. Officer's not required to memorize every single cellmate, cell location. So that, hey, Mr. Davis is exactly on 7D, room 9, room 11. It's not required today. He's looking at the car. Now, continues. Officer's head comes up, and look. Oh, happens to be the moment when that pole's there. Mr. Hamilton can't guess that. He's still standing there with like this. Why isn't he behind the pole? Why isn't he crouched over in the far corner hiding that? And then the officer just happens to look down again at the exact moment when Mr. Davis is turning the corner and starts to veer towards it. Mr. Davis, he's not snuck up on Mr. Davis. He sees him. What are not elements to these crimes charged? It's not an element that inmates have to act like they're not scared of each other. They have to accept the challenge. It's not an honor exemption somewhere in those instructions. The control room, whether or not they open the door, whether or not they're Metro employees, whether or not they have access, these are all actually really good questions, but they don't negate the responsibility of the two individuals that decided to go at it. Those are the two individuals who are being held accountable for those actions, not the control room. Control room, that's some job that may or may some manager may or may not have said, yeah, why'd you open that up? Is it unusual for an inmate to be alone in that room without an officer? Yeah, that's what they said. Doesn't negate a single element. Whether or not Nevada's facility would do something different than Kansas's facility, not in there. It's Roshan Hamilton and Dwayne Davis that decided to engage in that conduct. They are the ones that the state is standing before you today and saying, today, in this particular trial, is Mr. Davis's trial, hold him accountable for what he engaged in. Now, earlier when I said, look at how the words mirror each other, look at how the body position, no one has snuck up or gained an advantage. Look at how it mirrors each other. Squared off. Initial movement. Back foot gets stability by pushing off. Front foot gives to get power while you brace with the back leg. This is the first moments of this fight, and it couldn't be more mutual. Elements of battery, that's what you have been met. Mutual combat based on challenge to fight has been shown to you. Defendant Dwayne Davis is guilty, counts 1 and 2. And just for one last visual, when I just showed you those 4 photos, let's look at them again. Let's cut off the top. Fists clenched, squared off and feet angled towards each other. Going towards each other while bracing the leg, almost equidistant right there. Hands both now up in fighting position or attacking position, front leg bent. The push-off moment as they're really accelerating towards each other. Both leaning in the exact same way. It's not a defensive posture by one while the other's attacking. And then the moment of first contact, you almost can't make that up if you were going to. Look at that. Look at the hourglass figure, I guess, at the top. The bracing. It's the moment they first have contact, the bracing of the back leg and the front leg. This is mutual combat, and Mr. Davis is guilty of counts 1 and 2. Thank you.
This is the last part where you get to hear the verdict being read.
That's everyone, Your Honor.
Thank you. Please be seated. Do the parties stipulate to the presence of the jury?
Yes, Your Honor.
Yes, Your Honor.
Thank you. Has the jury elected a foreperson? That's Mr. Medina. Have the jurors reached a verdict?
Yes, sir.
Do we have the verdict? Thank you. Court will now read the verdict out loud.
District Court, Clark County, Nevada. The state of Nevada plaintiff versus Dwayne Keith Davis defendant. Case number C25389079-2, Department 4. Verdict. We, the jury in the above entitled case, find the defendant, Dwayne Davis, as follows. Count 1, battery by prisoner. Guilty of battery by prisoner. We, the jury in the above entitled case, find the defendant, Dwayne Davis, as follows. Count 2, challenge to fight. Guilty of challenge to fight. Dated this 9th day, April 2025, signed by Rodney Medina, foreperson. Ladies and gentlemen of the jury, is this your verdict as read? So say you one, so say you all.
Yes. All right, thank you. The clerk will now record the verdict in the minutes of the court. Does either party wish to have the jury polled?
No, Your Honor.
All right, thank you. Ladies and gentlemen, thank you for your service today. You are now released from your admonishment. You can speak to anyone about anything that happened in the courtroom, including what is taking place in the jury deliberation room. I will make myself available to answer any questions you might have. You can go back into the jury deliberation room, even the alternates as well. Thank you.
All right, to the front of the jury.
Thank you. You can be seated. So the defendant is still going to continue to be remanded into custody on this case. The sentencing date will be, let's see, May 27th at 9 a.m. Does that work with your schedule?
It does, Judge. I would request that the order be remanded without bail.
To be remanded without bail. Mr. Arnold.
Check that date.
Yes, take your time.
May 27th?
Yes.
Yes, I'm here. Thank you.
Thank you. So then a matter will be referred to the Department of Probation for a pre-sentence investigation report and set for sentencing on May 27th at 9 a.m. Thank you. Have a great day.
Thank you.
Judge, if you're gonna talk to the jury, you let them know we're willing to talk to them, if they wanna talk to them, we'll wait around for a few minutes to see if they want to.
I will, 100%. Can we have the IT switch the microphone back for the next trial? Yep.
And Mr. John, once you're both, if you want to stay, I'll just go grab the laptop so you can take that.
Sure.
Thank you.
Attorney here. I sat in this trial. I picked up this case. I started down here July 1. I picked up this case. And I did the motion for motion to limit. And I know exactly what I wrote and what I ruled. You can't use
Okay, I laid all that down on the record. I gotta go ahead and take it blurry off. So maybe I'll get it tomorrow. But anyway, y'all, sure you do some good for yourself and someone else. May today a good day and tomorrow a better day. And I am up out of here along with you. Be safe. Love y'all.